Lord, may I have a lordship kindly to mention one original side matter, my lord. Lord, urgency is this, my lord. Lord, construction is going on upon the existing roof of the basement plus ground plus 6 story 25 years old building. Lord, sanction plan was obtained, my lord, by way of third section 397 representation, my lord, submitted. My lord, no consideration, my lord. My lord, rapidly going on, my lord, illegal construction.
Nothing doing. No, sir.
My lord,
Mention on the original side day. Yes.
My lord,
Upgradation upon.
my lord, upon notice to the other side, my lord, mentioning this matter, my lord, the urgencies, my lord, I am the owner
Give
of.
the slip.
And we seek
Yes.
leave, my lord, to move a matter urgently, my lord, today before your lordship, my lord, subject to your lordship's convenience. My lord, this case, my lord, has
Is
some
the
background. My lord, I'm
urgency-
telling your lordship.
Proceed.
My lord, the petitioner runs a lawful cattle trading business, my lord.
Very good.
My lord, over here, this honorable court in the year 2011 and 18, my lord, thwarted two attempts of the government, my lord, to stop this business. My lord, either by way of trying to, my lord, demolish the area or, my lord, by way of cancelling his license. Both the occasions, this honorable court came to the rescue, said that you cannot do anything without giving him an opportunity of hearing. Lordship knows, my lord, very recently, my lord, in the area of Orphanganj, my lord, there was a fire which broke out. My lord, at that point of time, from the dais itself, my lord, the Honorable Chief Minister made a statement that they are going to relocate these persons, whoever were there, my lord, suffering because of the callousness, my lord, of the KMC, that they would be relocated in my area. My lord, I had approached a writ petition, my lord, before this honorable court. My lord, it was taken up yesterday. Now, my lord, yesterday it went before the coordinate bench of Justice Amrita Sinha, my lord. At that point of time, the learned counsel for the KMC said that since it was a municipality issue, the matter came about to be released, my lord, from yesterday's bench to be directed to appear before your lordship's bench. Now, my lord, what had happened, my lord, in the intervening night, my lord, what they have done, my lord, they've brought bulldozers and they are starting the demolition of my property, my lord, which the Honorable High Court, my lord, on two occasions have said that you cannot do it without giving me an opportunity of hearing. Nothing has been done, my lord. This is just a face-saving to, my lord, method, my lord. If, my lord, it is not taken up today, my lord, the entire property will go away, my lord, in its entirety. My lord, may kindly understands this urgency, my lord. This is my only humble prayer before your lordship, my lord, because everything is there, my lord. 11 and 18, two orders of this honorable court. And it is a lawful government licensed cattle business, my lord, which has been given to me. They once tried to remove that license. It has been thwarted. They once tried to.
We are not concerned with the license.
My lord, it is once demolition also. You have said that you have to give an opportunity of hearing. That happened in the year 2018. Now, my lord, all of a sudden, in one night.
These are sheds or buildings constructed with valid sanction plan.
Yes, everything, my lord. Everything is there, my lord. This your lordship can understand, my lord. Now, because of the last minute endeavor, my lord, I have to be given an opportunity. Now, the last minute endeavor is that since there was a fire which broke out there, everyone has to be shifted there. Otherwise,
You are trying to say that the demolition is taking place without any notice to you.
Nothing at all.
Nothing has been.
And my lord, nothing at all, my lord. And my lord, it is an admitted fact. Nothing has
No
been.
hearing has been.
Nothing at all. My lord, lordship can takes my lord, submission. Lordship can ask me even at the time of hearing. My lord, they are now with the bulldozers present there.
Have it at 2 o'clock.
Deeply grateful, my lord.
my lord, may I pray for leave to move one urgent matter, my lord, in this week at your lordship's convenient day. My lord, urgency is that the municipal authority already demolished some portion of our flat, my lord.
Very good.
The petitioner purchased the flat, my lord, after obtaining loan from the bank authority, my lord, without giving any opportunity of hearing, without giving any prior notice, my lord, the municipal authority, my lord, started demolition proceeding. My lord, lastly on 10th of July, my lord.
You have a sanction plan for the building?
Yes, my lord. G+2. I am the. We are the owner of the flat. We are the purchase. We have.
Doesn't mean you have a sanction plan.
Yes, my lord. I have my sanction plan, my lord. G+4 story sanction plan.
Which floor are you living, sir?
My lord, no extra floor, my lord. Municipal authority alleges that after deviation, construction has been made. My lord, we don't know anything, my lord. We purchased the flat, my lord, after
Let it
obtaining.
come in the due course.
My lord, kindly consider, my lord. My lord, kindly consider. My lord,
My lord,
my lord, municipal authority already demolished my lord, some portions of our flat.
Claim damages.
My lord,
My lord, this
my lord,
is
damages.
my lord, I have the sanction plan, my lord. G+4 story sanction, my lord. G+4 story building has been constructed.
Damages.
My lord,
Builder floors, I know how it is.
my lord, kindly consider, my lord, no notice of hearing, no prior notice of, no opportunity of hearing, my
File
lord.
a petition, then mention it.
My lord, kindly
My-
consider, my lord, in this week, my lord,
This is
and
a matter-
any day, my lord.
No. Yes.
My lord, there is a matter regarding unauthorized construction. The interim order, it was passed on 10th July and it expired on 12th July. My lord,
Yes,
my
My
lord,
lord, item number 32 of yesterday's list,
Yes.
your lordship dismisses for default.
Very
I
good.
was just about to come in the yesterday.
Very good, sir. We will wait for you to come. You take a stroll.
No, sir, I was.
Why are you mentioning the matter? Move an application.
Sir, kindly restored matter.
Is this the way restoration is done?
No, sir.
How long you have been practicing?
Sorry, sir.
How long you have been practicing?
5 years.
This is what you have learned.
Sorry, my lord. Apologies.
Your lordship, may I
Yes.
permit to mention a matter at the cost of reprimanded, my lord. My lord, this is an urgency, my lord. My petitioner filed this petition against an unauthorized construction after receiving the petition from.
Sir, give your
this-
slip.
My lord, it's for upgradation, my lord.
Give your
Lordship. By the private respondent, my lord.
assaulted, go to the police.
My lord, we have filed the complaint, my lord.
Very good.
My lord.
Very
My
good.
lord, otherwise, my lord, the
Very
construction.
good. Police in action. File a petition. Next.
May your lordship be.
I'm sorry to disturb the court. My name is not recorded in this order, lordship.
May your lordship be permitted.
Madam, where is the other side? What is the way of mentioning? Madam, who's on the other side? Where are they? Wait for your turn. Nobody mentions like this.
May your lord.
Point mentioning, I can understand. You can't just come and mention without the state being there.
May your lordship be permitted me to mention this urgent matter for upgradation.
Give your slip. Give your slip. Give your slip.
I'm praying for upgradation, my lord. If your lordship permits me, I can place the urgency in 2 lines, my lord.
Give your slip. We'll see that.
I'm so
Wait,
grateful.
please, my lord. My lord, it's for inclusion in the list.
Give your slip.
Much obliged.
Give your slip.
That appellate side matter, my lord. Upgradation, my lord.
Give your slip, sir. How many upgradation you have? Call out the list.
But I'm for the petition, my lord.
With the above direction, the writ petition disposed of with the same directions.
I'm good.
Date.
To the wait together.
Manoj. Manoj. फाइल में देख लो कोई एप्लीकेशन तो नहीं है. Next.
To also I am for the petition.
Accordingly, the impugn order is hereby set aside. The respondent authorities are directed to pass a fresh speaking order within a period of 2 weeks from the date of communication of this order. The decision shall be made strictly in compliance with the direction of the Honorable Division Bench in its order dated 13th August 2024 in MAT 594 of 2024 in accordance with the West Bengal Municipal Employee Rules 2003 and after affording an opportunity of hearing to the petitioner for the purpose of calculating his qualifying service, his absorption shall be deemed to have been commenced from his initial date of appointment, which is 4th of June 1991. With the above direction, the present writ petition is disposed of.
Put June 19. I'm good. देखिए देखो पर नहीं
ये चले जाए हमारा
है
Yes.
Item number 3 appeal for petition. And I'm being led by Mr. Bilodal Bhattacharya. On the last occasion, my lord had passed an order. My lord kindly recall this pertains to my lord that punitive transfer order of an employee of the municipality. My lord was of the opinion, kindly take your lordship's last order dated my lord 20th May. My lord kindly sees paragraph number 4. May I read, my lord? Respondent number 1, 2, and 3 have filed their affidavit in opposition, commencing in assertion that the deponent has been advised to deal with only those allegations which are material and relevant. Upon perusal of the said affidavit, it is evident that the respondents have failed to disclose any cogent reason underlying the impugned transfer. The affidavit merely asserts that as per the West Bengal Municipal Employee Service Rule 2010, the respondents vested with authority to effect such transfers. However, it is not the case of the respondent that the transfer was effected on the ground of administrative exigency or efficiency. No adequate justification has been provided by the respondent state for this unusual and exceptional transfer of the petitioner. In view of the above, this code directs the respondent state to disclose the reason for effecting such unusual transfer. Accordingly, respondent state is directed to file an additional affidavit within a period of 4 weeks from the date of this order, clearly setting out the reason for which the impugned transfer. The petitioner is permitted to file reply to the same. Well, the affidavit, my lord, is my lord, with lordship's leave, my lord, may I be, my lord, permitted to refer to a, my lord, judgment, my lord?
Want to file a reply to this affidavit?
Now it's to go on. दिए थे
Yes. What are you trying to show?
My lord, from a my lord, cursory glance, I could not find my lord, any additional reason, my lord. My lord, I was my lord, praying with your lordship's leave, my lord, to refer to judgment of the Honorable Supreme Court reported in my lord 1978, Volume 1, Supreme Court cases, page number, my lord, 405, paragraph number 8, my lord. That it's a celebrated case, my lord. May I, my lord, may I hand up the tab, my lord?
Where is the, give the citation, give the
My lord,
copy.
1978, Volume 1.
No, no, give the
Supreme Court
copy of the
cases.
judgment.
My lord, I have asked for the book, my lord. The bar is not yet open, my lord. That's why I
You
my
could
lord.
have taken a printout and given it.
My lord, I am extremely, my lord. I apologize, my lord.
Should carry printouts for the court.
My lord, I am extremely apologize. I asked for it, my lord, but my lord, because of the weather condition, my lord, everyone is, my lord. My lord, may I, my lord, read out the paragraph, my lord? So,
You want to file your reply to this?
my lord, kindly keep the maintainability of the affidavit open, my lord. Because my in view of this Supreme Court judgment, my lord, the state respondents are not be permitted to bring additional ground, my lord.
Mohinder Singhal. Mohinder Singhal.
I have directed them.
My lord,
I have passed an order.
my lord, in view of this order, my lord, I was just, my lord, referring to it, my lord. My lord, I will, my lord.
No question of maintainability of additional.
Your lordship has directed them.
My lord,
I have directed. Read it out.
second second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by reasons so mentioned and cannot be supplemented by fresh reasons in shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by time it comes to court on account of challenge, get validated by additional grounds later brought out. That's
Not applicable. You want to argue today or you want to file your reply to this?
I won't file my reply.
Learned counsel for the petitioner seeks 2 weeks time to file his reply to the additional affidavit filed by respondent number 1, 2, and 3. Let this matter be listed after 4 weeks.
After Mota judge.
If you want to argue, we can finish it off.
I will on the next day, my lord, I will
After 4 weeks.
my lord, the interim order, my lord, it was passed earlier.
Yes. Interim order granted so and so is extended further for a period of 6 weeks.
So great.
Interim order 6 weeks after 4 weeks. When is it expiring?
My lord.
Interim order.
Interim order, my lord, on the last occasion, it was passed for my lord, 10 weeks.
So when is the
So,
10 week getting over?
End of this month, it will be expiring.
End of this month.
29th July.
29th July, my lord, is supposed to
29 July.
supposed to expire.
So let's finish it on 28th of July. Keep it for 28th of July.
20th of July.
28th July.
আমাকে একটা copy দে।
Fine.
It will be 3 weeks, I guess. You file it in 1 week, we'll have it after on 28th of July.
As the lordship has.
6 1 weeks time to file his reply. List it on 28th of July for hearing matter.
As the lordship. But my learned senior will not be available on that. We'll come back on the 28th, my lord.
But I understand, my lord, today they have just filed their additional affidavit, my lord. I'll take the point also, my lord, of Mahinder Singh Gill's, my lord, that this is the post-decisional reasons, my lord, that they are trying to introduce. We'll argue it and, my lord, we'll finish it out on the 20th.
আপনি একটু দিকটা যান, না দেখা দাঁড়াবে আমার কর্পোরেশনের জায়গা নেই।
My lord, I appear for the applicant in Can 1. Lordship had taken this up yesterday. My lord, we've checked the law. My lord, corporation can't even make this submission that they're entitled to keep my goods under padlock, my lord. As my lord.
I just court staff informed that there is some issue. Tomorrow.
Great.
We are not able to find them.
Next Tuesday, my lord, junior has some difficulty. And 21st also there would be some difficulty. As I understand, because the entire traffic will go there on 21st. A lot of traffic on next Tuesday.
Tuesday, I have a problem.
Lordship.
No, tomorrow is an auspicious day. I mean, as far as Mr. Mukherjee is concerned, what's the difficulty with tomorrow? Yes, yes, tomorrow. Pretty auspicious.
Tomorrow.
It is auspicious for us.
It's appearing for extension and there was direction to produce.
Lordship, I am for HMC and led by Mr. Shondiban Banerjee. Mr. Banerjee is engaging.
Directed to produce record and the matter.
Court number
was directed
26.
to
I
appear
bring
and
for
it's
short
appearing-
pass over.
I am for the private.
It's appearing for extent, sorry.
May I say only one thing, my lord? In view of an order passed by a coordinate bench in the contempt proceeding, violation whereof has been complained in this order, my lord, in this writ petition. But kindly see once, my lord, this order, this writ petition has become infractuous. They have filed this writ petition challenging an order of demolition on the ground that the earlier order passed in the earlier writ petition, my lord, the direction was to, my lord, serve inspection report and to, my lord, give opportunity of hearing. They have complained, my lord, the violations of this in this writ petition. My lord, kindly takes up this order, my lord. There was a contempt pending, my lord, on my behalf, my lord. On that day, my lord, I have, my lord, made categorical submission before the coordinate bench that I do not have any opportunity if they will be given another opportunity of hearing.
They said that.
That has been allowed, my lord. Kindly seize the.
They said that the impugned order may be set aside and the earlier direction may be directed to be complied
That
with.
has been done.
For that, it will not become infractuous. It will be allowed on that order. That this order, they say that should be set aside. And the direction admittedly not complied should be directed to be complied with. Therefore, my writ succeeds. It will not become infractuous as submitted. And the, sorry.
He is saying in a different sense, he is interpreting the order to the extent that this will become infructuous because you have been granted the right by the coordinate bench for a on-spot inspection report and the hearing. So that is the reason why this writ petition becomes infructuous.
No further order is required.
Kindly look to these two orders. Therefore, the action taken by corporation is apparently bad. They accept it. Both corporation also accepts it. Therefore, it has to be set aside in the light of the order passed. Because without complying the earlier direction, they came to demolish. Your Lordship also directed them to produce record. The earlier direction was also to produce record. Therefore, the action taken for which writ was filed admittedly becomes, my lord, successful. And the contempt, moreover, cannot be proceeded further because the order passed by that court stood complied with. Since corporation is not here, but this can be disposed of. There is no doubt, my lord, that it can be disposed of recording that
Tomorrow.
Tomorrow.
Tomorrow. Not today.
Grateful Lordship.
Lord, Lord, in the earlier two orders, there was direction on corporation to bring record.
They will bring it. She is here.
It's for corporation.
My lord, the HMC is here. My lord,
चले गए
My lord, item number 6.
Possibly, my lord, possibly they have not brought the record. So far I understand.
Madam,
If
bring the record tomorrow. Your senior also just went away.
let it be one day thereafter so that they can bring it.
No, tomorrow.
Otherwise, again the same position.
Bring the record tomorrow.
They are
Record as
grateful, Your Lordship.
My lord, item number 6. I appear on behalf of the petitioner.
My lord, in
My
item
lord,
number 6, Lordship,
regarding self-same property, there are
there
two
is
writ
a
petition, my
direction-
lord.
There is a direction to tag my writ petition with this writ petition. It was not tagged, Lordship. My lord,
My
I
lord-
am praying not today. Let the matter be tagged with this.
हाँ हाँ नहीं है इस पे आना चाहिए ना ऑर्डर क्यों कंप्लाई नहीं हो रहा है Ask the listing why the orders are not getting complied. We'll have it tomorrow.
My lord, let the interim order be extended, my lord.
Tomorrow.
Grateful.
My lord, I am for the petitioner, my lord. Mr. Banerjee, I have served about him, my lord. This matter pertains
Mr.
to
Banerjee
our-
was here. He just went to the other court. Huh?
Has come upon my mentioning. Yesterday I mentioned the matter, my lord. This is the matter where there was an interim order, my lord. Subsequently, that interim order.
Lordship, I am for HMC and led by Mr. Sandipan Banerjee. Mr. Banerjee is engaging court number 26. I praying for short passover.
Can it be taken up second up, my lord? Any time.
We'll see Passover.
Because as per the notice, they were supposed to.
We can have it tomorrow.
We can.
Tomorrow,
Then-
tomorrow.
Yeah.
Grateful Lordship.
Tomorrow. Not today.
I am for the petitioner, my lord.
My lord, I am on behalf of Kamarhati municipality.
Last occasion, there is a direction to file an report by the way of affidavit, my lord.
Where is that, madam?
Not mine.
Upon state, my
State.
lord.
Yes.
Your lordship directed the department to take decision. Malat, I sent it to the concerned authority. Malat, they have replied that for regularization of leave, municipality is the authority, not the government.
Sir, you file your report. We'll see
Malat,
that. Where is the
municipality-
report?
Kindly, in terms of the instruction, only
Sir-
dispute, everything is clear. Only dispute unauthorized leave of almost 3 years. That is not reflected in the service book. That was the objection was raised. Your lordship directed the department to regularize and file a report. Department said is the municipality is
He
the
has
authority.
been made a ping pong ball. You're sending him from here to here, here
Municipality
to
is
here.
the authority to. If
Where is the report, sir, in view of the order passed by this court? Where is the report?
Then I have to file the report, because since they said they are not the authority, municipality shall regularize the leave.
Sir, please file your report.
Malat,
There's a
Malat.
direction from the court.
Within a week, I shall file the report. Within a week, Malat.
If you see, sir, the last order, it is very
My lord, I
clear.
have seen.
The
I have seen.
municipality has already replied to you that rule is not applicable. You failed to take any decision.
No, my lord, subsequently, the
Sir,
director of local bodies have,
read the order.
my lord, I have seen, my lord, I have seen, but the director of local bodies have cleared everything.
Your director of local bodies is
Objection
overjealous about everything.
No, my lord, I am not supporting the case.
Sir, please see, it is not even applicable.
My lord, even
Why you are not taking a decision?
my lord, that
You
decision,
wrote to them,
my lord,
they replied to you.
my lord, kindly, my lord, I will file a report. My lord, kindly only dispute with the regularization of the leave.
Regulation of the leave is
Yes.
not applicable. What you are quoting is not applicable to the petitioner.
My lord, that rule says that in terms of the earlier rule. But I am saying, my lord, that 2010 rule
Can
says
you please file your
that-
reply and then I'll pass an order.
I shall. In terms of
I
that,
don't need to agitate this issue with you.
my lord. My lord, I shall file a report with the my lord explaining. My lord, this rule, my lord, not question of applicability of this rule. This rule says
67(2) is not applicable.
my lord, why? My lord, kindly see, my lord,
Sir,
kindly,
why don't you file your reply and explain
my
things?
lord, kindly grant me
What
one-
is stopping you from filing reply?
my lord, I shall file.
Why you don't comply with the orders of the court?
My lord, I shall file. Kindly grant me 1 week time. By that time, I shall file. My lord. My lord, kindly grant me 1 week time.
Just troubling people, nothing else. Not expected of you, Mr. Bari.
No, my lord, since
Sir,
they have said the municipality is
Unfortunate
the-
approach from your side.
no, my lord, I shall file the
From
report.
lawyers like you.
My lord, I shall file the report explaining the my lord, what is the situation and who is the competent authority to regularize the leave. My lord.
Learned counsel for the respondent number 2 seeks and is granted further time of 1 week to file his affidavit. The report by way of an affidavit. Exception to the same, if any, be filed within 1 week thereafter. Learned counsel for the respondent. You file yours also. We will finish it off, whatever stand you have to take. Learned counsel for the respondent seeks and is granted. Respondent's Kamarati municipality seeks and is granted. Dono ka do week kar do. Learned counsel for the petitioner seeks and is granted for the time of 2 weeks to file his report by way of an affidavit. 2 weeks for the municipality, report by way of an affidavit. Exception to the same, if any, within 1 week thereafter. List after 4 weeks.
Deeply obliged, my lord.
He has become a ping pong ball between both of
No,
you.
my lord, extremely sorry, my lord, I shall file the report. My lord.
These are people who have worked for 36 years, 38 years,
My lord,
and you don't want to release their retirement benefits.
my lord, we have cleared everything. Only dispute regarding sanction of a particular leave. My lord, nothing else. My lord. Everything, entire pension paper has been prepared and it was sent to the my lord, accounts
You
section.
have already received a reply from the municipality. Still, you will continue harping on the same issue.
My lord, I shall file a report explaining the present situation and who is the competent authority, my lord, to regularize the leave. My lord.
You also file your report, madam.
Yes, my lord.
Great.
And Lord, I am appealing for the petitioner in this matter. Now, my lord, the writ petitioner, my lord, herein, my lord, challenges, my lord, the notice, my lord, I would say, rather an order, my lord, page 27 of the writ petition. Now, what happened, my lord, under the Pradhan Mantri Awas Yojana, that the petitioner was made to, my lord, was issued a sanction plan. My lord, in accordance with that plan, my lord, the construction was going on. My lord, a dispute arose with respect to the construction between, my lord, the parties, my lord. And my lord, we were a stop work notice, my lord, which had no basis, which compelled us to initially in the first round of litigation come to Honorable High Court. Honorable High Court, looking at the notice, my lord, directed the authorities to look into the issue and my lord, come to a conclusive finding. Now, my lord, on that basis, when the hearing was going on, my lord, if my lord takes up, my lord, the page 29, my lord will find 2 installment under the scheme was issued on the basis of which 4-5 pillars have been constructed. My lord has found, my lord, page 29. Now, my lord, at the stage of the construction is this. Now, my lord, what happened, my lord? They found, my lord, one of the pillars, my lord, might be here and there. Though, my lord, we are not being told, my lord, what is the nature of deviation. But, my lord, they say there is a deviation, my lord, which is going beyond the plan which was sanctioned. Now, my lord, be that as it may, kindly turns to page 27 once. Now, in 27 page, my lord will find they write a letter to the petitioner wherein they inform. This is to inform that since you have deviated from the sanction plan, so your building plan under housing for all scheme in respect of such and such was cancelled as per Board of Councillors meeting resolution dated such and such. In meeting, lawyer was present. He was informed of the decision. In this context, please be noted that you are granted an amount of such and such against the scheme. This amount should be refunded to the municipality within 15 days date of the receipt of the memo, as you have violated the sanction plan. Now, my lord, this is under challenge. My lord, my respectful humble submission today is, my lord, even if, my lord, I take it on the face value, though I do not have a report what is the nature of deviation, not never handed over to me. But even if I take it on the face value, my lord, deviation from a sanction plan cannot be a ground for rejection of a sanction building plan. Now, my lord, I need to, my lord, correct that. My lord, the pillar, if one of the pillar is out of the shape and under the scheme, my lord, it is mandated that my construction should be, my lord, under the vigilance of the executive engineer, who will see that whether the plan which is being granted, construction is made phase by phase in that manner, and up to every phase, my lord, I will be sanctioned amount to complete the construction under the housing scheme, my lord, under the Yojana. Now, my lord, this sanction is absolutely dehorsed the law. My lord, my challenge is to this cancellation.
Yes.
My lord, cancellation cannot be done.
Yes.
Either, my lord, I am entitled to the scheme, or, my lord, I need to correct some deviations if it has happened. Now, my lord, this is my submission for the time being, subject to what response come from them. Because under the Municipal Act also, my lord, no scheme about. Now, if my lord takes section 210 of the Bengal Municipal Act also, my lord will find
Nineteen
1993. Section 210, my lord. My lord, for cancellation of a sanction building plan, my lord, grounds are enumerated. My lord has got that, my lord? My lord, if my lord sees the ground A, B, A to F, my lord, none of the grounds apply to.
This is different.
This is different, absolutely.
This is different, sir.
My lord?
This is grounds on which sanction can be refused.
Yes.
This is not applicable.
Absolutely. That's why I say, my lord, even today, my lord, if their case was, my lord, I obtained the sanction plan, my lord, suppressing something.
In your case, how is this applicable?
Not applicable. That's why I say, my lord, under the Municipal Act, nothing applies to my case.
Yes. Yes.
But admittedly, there is a deviation, madam. Now the municipal.
What is the deviation?
The pillar which they have constructed is outside their portion.
So for deviation, you'll
No,
cancel the sanction plan.
we are not cancelling. We have stopped the sanction plan. My lord, we have given them the hearing. But nothing came out. My lord,
So the letter says you have cancelled.
My lord, first time, no.
Please read your letter. You have cancelled the sanction plan. You have asked them to refund 15 lakhs.
No, my lord, 1,40,000.
1,40,000.
Which they have got. My lord.
Yes.
Because they have, my lord, they have
Sir,
deviated.
first of all, let us go one by one. Deviation, does it amount to sanction, cancellation of sanction plan?
No, the sanction plan has not been cancelled.
Then how have you cancelled the sanction plan?
Lord, we have not actually cancelled the sanction.
Not actually. What? Sir, I'm sure you understand English.
Yes, sir.
Please read your letter. What is the word used? Was cancelled. This is to inform you, since you have deviated from the sanctioned building plan, so your building plan under housing scheme in respect of so and so was cancelled. as per Board of Councillors meeting resolution dated 31/7/2023. Do you read it, sir?
Yes, my lord, let me come up with a report, my lord, on this. Let me come up with a report.
How have you cancelled it?
So will be cancelled. Lord, let me come up with a report.
Why a report? How have you cancelled? You show me the law, sir. Deviation amounts to cancellation of plan. Please show under which provision of law. There's the Pradhan Mantri Awas
scheme, my lord. I mean, under this scheme, these projects come up under a supervision of executive engineer. If they insist, my lord, it is going because the machinery work I am not supposed to know. My lord, the person having the plan, my lord, is constructing as per the plan. If something goes here and there, the executive engineer supervising it can correct it. That one of the pillar is falling apart. You put it inside.
in the Central Sanctioning and Monitoring Committee. Huh?
Yes. There is a Central Sanction Monitoring Committee.
Yes, sir. Under which law?
Let me come up with a report, my lord. So, second round of litigation, my lord,
Tell your Board of Councillors to stop acting like this. There is some rule of law which prevails. You're not in a jungle, Raj. I'll set it aside. The petition, the present writ petition, comma, is aggrieved by the impugned order dated 15/5/2024, issued by the chairman of the respondent municipality. Chairman, Kamarhati municipality, comma, whereby it was informed that the Board of Councillors, comma, in its meeting dated 31/7/2023, comma, had passed a resolution to cancel the building plan sanction under the housing for all inverted comma kar dena, housing for all scheme in respect of premises number 18/A, Rojan Bagan, Kamarhati. On the ground that the petitioner had deviated from the sanction plan. The said communication also directed the petitioner to refund a sum of rupees 1,40,000, which has been disbursed to him under the Pradhan Mantri Awas Yojana scheme. Full stop. Counsel for the petitioner submits that he was constructing a house at the aforementioned site under the Housing for All scheme, which is a central government initiative under the Pradhan Mantri Awas Yojana. Full stop. The building plan has been duly sanctioned by the respondent municipality. Full stop. While he was carrying on the construction, the petitioner was served with a work stop notice dated 15/12/2022. Full stop. In response, the petitioner submitted a representation dated 17/1/2023. Full stop. In response, however, there was no response from the authorities. Full stop. You had filed a writ petition.
Yes, I filed a writ petition.
The petitioner approached this honorable court by filing WPA number 4712 of 2023. Full stop. Justice Sinha's order.
Justice Sinha's order.
Wide order dated 19/4/2023, this court disposed of the writ petition with a direction to the respondent to pass a speaking order after affording an opportunity of hearing to the petitioner. Full stop. Since no steps were taken by the respondent authority in compliance of the said order, the petitioner filed a contempt petition being CPAN number 1218 of 2023. Full stop. In course of the said proceeding, the respondent produced the order dated 15/5/2024, whereby the petitioner was informed that the Board of Councillors had resolved to cancel the sanction plan and further directed the petitioner to return the sum of rupees 1,40,000 disbursed under the scheme. Full stop. Learned counsel for the petitioner contends that the ground on which the sanction plan has been cancelled is merely on the basis of deviation in constructing the pillars. The learned counsel petition states that at best, even if the ground of cancellation is to be considered to be correct, the petitioner has only undertaken construction of the pillars on the said site and no further construction has been done. it is the submission of the learned counsel for the petitioner that on the ground of deviation, his sanction plan cannot be cancelled. Full stop. Even assuming that there is a deviation in the said construction, no notice has been served upon the petitioner. Full stop. Neither he has been communicated of the nature of deviation which has been carried out during the course of the construction. Full stop.
Hearing was given, madam. Hearing was given.
Sorry?
Hearing was given to them. It is not that we have communicated to letter. They were present.
Hearing you have given, yes, this is there on 15.5.
They were present during the course of the
That's right.
decision was taken.
Yes. I'm saying the notice and deviation. What is the deviation? The nature of deviation. क्या लिखा है? During the course of the has been communicated to the petitioner. The petitioner contends that since the construction was undertaken under the housing for all scheme, comma, the competent authority to cancel or recall the plan is the Central Sanctioning and Monitoring Committee, bracket mein CSMC, bracket close, full stop. Counsel for the petitioner contends that the municipality had no jurisdiction either to cancel the sanction plan or to demand refund disbursed under the said scheme. He further contends that without granting him any opportunity of hearing, the sanction plan has been cancelled. Full stop. Learned counsel for the respondent submits that by the impugn order dated 15/5/2024, comma, the chairman has communicated the decision of the Board of Councillors. Full stop. He further states that the lawyer for the petitioner was present in the meeting and he was communicated of the decision. Full stop. Counsel for the respondent further states that since the sanctioning authority is the respondent municipality, they are well within their rights to cancel the sanction plan. Full stop. Learned counsel for the respondent states that no notice of deviation has been given to the petitioner. Full stop. He has further failed to point out that in case there is a deviation in the property, will that lead to cancellation of the sanction plan. Has failed to point out the relevant section, which pertains with the cancellation of the sanction plan in case there is a deviation from the said plan. Full stop. This court has heard the arguments advanced by the counsel for the parties and has produced the materials on record. It has been rightly pointed out by the learned counsel for the petitioner that the construction was being undertaken under the Housings for All scheme. Full stop. On a plain reading of the impugn order and the resolution of the Board of Councillors, comma, it is evident that the allegation of deviation from the sanctioned plan, comma, has been made without any specificity as to the nature or extent of such deviation. The petitioner has placed on record photographs of the alleged unauthorized construction, which merely shows the presence of pillars on the site. Even assuming there is deviation, comma, cancellation of the entire sanction plan is not justified in law, comma, at most, comma, the extent of the deviation should be identified and corrective actions may be required. Full stop. Upon a careful perusal of the impugned order dated 15/5/2024, this court, this court finds that the same reflects complete non-application of mind and is vitiated by arbitrariness, comma, the impugned order, the impugned decision neither specifies the nature nor the extent of the alleged deviation from the sanctioned building plan, full stop. It is settled principle of administrative law that any action having civil consequences must be preceded by due adherence to the principle of natural justice, comma, including the right to be heard, full stop. In the instant case, comma, no notice of hearing was afforded to the petitioner prior to the cancellation of the sanctioned plan and the demand for refund, full stop. Further, the respondent authority has the order is thus not only procedurally flawed but also substantively unsustainable. The cancellation of approved plan without identifying the deviation or offering an opportunity to rectify the same is disproportionate and contrary to the established principles, established norms under the municipal law and under the municipal law, full stop. Hence, the impugned order is liable to be quashed and set aside, full stop. Consequently, comma, the matter is remanded back to the Board of Councillors of the municipality for reconsideration of the issue in accordance with law, full stop. While doing so, comma, the board shall specify the nature of deviation from the sanction plan, full stop. The respondent shall be at liberty to conduct a fresh joint inspection of the premises in the presence of the petitioner, full stop. The board shall the respondent authority shall consider if the nature of deviation, comma, extent of deviation and the impact of the deviation before taking any decision as far as cancelling of the building plan is concerned.
Not subject to correction, my lord, this part. My lord, if there is a deviation, my lord, that would be rectified instead of going to the cancellation of the
All right,
building plan.
then, all right, इसको change कर दो. The respondent shall identify the nature of deviation and grant an opportunity to the petitioner to rectify the said deviation. Full stop. The petitioner shall be afforded a reasonable opportunity of hearing before passing off of any order for cancellation of the sanction plan. Full stop. With the above direction, the present writ petition is disposed of.
One indulgence, my lord. Correction, my lord. In the EOC, my lord, Guru Councilors meeting on 31st July, my lord, all the parties were present where decision was taken for cancellation, though they were aware.
All right.
That
The
they were-
petition,
It is not that they were not aware. It is page 16, my lord. Page 16.
you were given a hearing.
Yes,
My lord,
my lord.
on the, my lord, the
My lord,
direction of
last-
Justice Sinha, my lord, we are called for a hearing, but my lord, the report was not handed over to us, nature of deviation.
All right, I'll just confine you to the nature of deviation, not the hearing part.
Very
The
well.
hearing part I'll
Yes.
remove that. वो जहाँ hearing लिखा हुआ है ना, no hearing was given, उसको हटा देना बस. हाँ, what?
Lawyer, ठीक है, lawyer of Roshan was present. ठीक है,
15-5. Decision. ये रहे. सिर्फ वो hearing हटा देना, ठीक है? We'll only confine it to the deviation.
And
We'll only confine it
yes,
to
very
the.
well. Well, kindly, I will rectify this, my lord, if there is. They say that this has to, pillar has to be shifted. It would
Whatever
be
it is, they'll communicate the deviation
yes,
to you.
yes, we'll rectify this.
Deviation will not amount to cancellation of a plan.
Absolutely.
At least an opportunity should be given to you to rectify the deviation. If that can be done, it's
Well,
okay. If that
furthermore-
can't be done, then you cancel the plan.
My lord, only furthermore, one thing, my lord, at this stage, I am apprehending because of these 2 rounds of litigation, petitioner will suffer a heat. Now, my lord, let the construction come up under the supervision of some expert body at this stage, my lord, may I pray that.
Not at all.
My lord, affidavit of service, my lord,
Affidavit of service taken.
Under compelling circumstances, may I permit to mention one matter, my lord?
Not at this time.
Regarding the determination of Justice Chandra, my lord, just now, my lord, there is determination was
Not at this time, sir.
My lord, I am appearing for the petitioner, my lord. From last document, I am told by clerk of Mr. Shumon Basu, he is appearing for the municipality, my lord. Shumon Basu. He is paying for a Passover, my lord, kindly. My lord, he is arguing a matter in another court, my lord, kindly.
Not today. Milad. You are appearing, Mr. Banerjee, in this matter?
11 I am there for.
11 and 12.
But
Officer to take 15 also.
as per my instruction.
11 and
11
15
has
are together.
become
11 I am the
structural.
petitioner, my lord.
11 and 15.
I appear for some of the respondents.
11 and
I have a.
As per my instruction,
Sir,
this
sir,
petition has become
15
infractual because of the fact the petition alleges of making a complaint before the corporation seeking cancellation of the plan. That representation has been heard out by the additional municipal commissioner, who has already passed an order on 28th of March 2025. So by passing of that order, my lord, this first writ petition, that is item number 11, has become infructuous.
It has not, my lord, I am the petitioner, may I submit, my lord? It has not become infructuous, they have passed an order, my lord, staying the, my lord, plan. Our prayer is complete cancellation, and after the filing, my lord, some events have taken place, subsequent events, my lord, which we want to bring by way of a supplementary affidavit. Now, this was appearing in the monthly list, my lord, 2024 matter, somebody has mentioned and got it upgraded, my lord. In the morning, I came to learn it is appearing. If your lordship kindly permits a week's time, my lord, to be given to me, I'll bring those documents. There's a suit in which, my lord, the civil court has directed both parties to maintain status quo in view of the allegation of forgery, deeds being obtained by forgery, applying and getting sanction plan. Now, what they are doing, the scheme is, my lord, by way of these forged deeds, plan sanction, they will sell off the property and go away. That cannot be done. Corporation has not interfered.
Last sentence, my lord,
Yes, yes. But I have to bring those
documents.
documents on record. They have got the matter upgraded suddenly, my lord, appearing in the month, month 2700, it was appearing.
we are upgrading matters. Every day we try to upgrade at least 8 to 10 matters.
If
So
it
that-
upgraded, well, notice should have been given. I don't know whether notice has been served or not.
They might have
Generally
given a
notices
notice
are-
mentioning notice, but I did
Notice
not
has
know it will come up today at item number 11. I'll
This
put the
court
matter.
is upgrading matters. We are trying to upgrade matters so that we finish off whatever we can. People who are
I only
interested,
want to
let's
file
finish
a
their matter.
supplementary, my lord, bringing on record those subsequent events, my lord. One is the subsequent order which,
Mr. Banerjee,
my lord,
I follow the argument of other Mr.
my
Banerjee.
lord. No, Mr. Mukherjee.
Mr. Mukherjee. Mr.
Yeah,
Brahman,
Mr.
both both are same, Brahman.
Mr.
During
Bisru
pendency,
Mr. Bisru Mukherjee, to the extent that he is right, there is an order which has been passed by the additional commissioner. Now, as far as that is concerned, what you have sought in here,
No.
that is
that is not completely read. We want cancellation altogether. They have not stalled. They have said it is plan, let the construction be stopped. But it's not a final decision, which is my prayer. My prayer is that in view of the forgery and the series of litigations which is suppressed, in a craftsman, the matter is that one co-sharer obtaining a plan in respect of the entire property, we are the other co-sharers.
this, as far as the cancellation is concerned, cancellation is subject to the outcome of the civil dispute.
Absolutely.
There is nothing which this court can do as far as the cancellation is concerned. You get the order from the civil court that all this forgery, blah, blah, blah has taken place. You'll get a, today, as far as this court is concerned, the writ court, no cancellation order can be passed.
No matter today, may I 11 and 15 both, may I suggest one subject to my lord's sanction and my lord's sanction? Building is complete. Only thing is coloring and some windows are left out. Monsoon is coming. Can you allow me to complete that and injunct me not to sell, transfer, alienate anything? And what my lord has proposed, this should be decided if it appears admitted to your co-sharer. So I have a right in every inch. So on that basis, I have constructed. If ultimately in a partition or where it is done, that partition should court will decide.
There's an injunction, it cannot be done, my lord.
Right.
Civil court has
Not
injuncted.
do anything.
Now,
On
the face of the order,
তুই কার হয়ে আবার?
52 ballot.
তুই কার হয়ে?
Respond number 7, sir. Yeah, order page. On page 52 ballot, there's an order of status quo.
They cannot-
Page 52.
they cannot ask
Sir,
for.
in writ 21252, you're talking about?
Yes, ballot. Yes, ballot. Page 52.
I don't have page 52.
21252
The
Ballot,
writ
Item 15.
15 ballot.
15 though, eh?
এই 15 টা দেন
15, item 15.
বললাম যে 15 টা
Lord,
Yes, Mr. Chakravarti.
in 15, I am
Sorry,
appearing
I am
for,
left out.
I am,
Sir, abhi no, sir.
I am appearing for
Mr.
respondent.
Basu, there are other people also in this.
No, let's not be, my lord, on this. My lord,
Yes.
I appear for 8 to 11. Now, my lord, in this tug of war, we are the tenants, we are suffering. The building is complete. I believe it's a collusive matter. They are not allowing us to enter into the building.
Not
Take the
collusive
photo.
at all.
No, my lord,
It's a fight between.
we are the tenants. The building is complete. Let us get back to our possession. Let them fight forever to come.
Unless the completion certificate
Lord, the
is
building
obtained.
is complete.
I don't understand.
Building is done.
Good for restitution if they are illegally disposed.
They are fighting.
Enter into the premises.
Without completion
Without a
certificate.
completion certificate, how can you occupy?
How does it enter?
How can that?
But my point is that we are suffering in this thing, Lord. We are made to suffer. That's the only thing.
The order, my lord.
Claim your
And Lord-
damages, whatever you have to do, tenant.
But Lord, we were in possession. Now this is the difficulty that we are suffering.
You can
That's
suffer.
the only thing. Now with regard to
Where your
water, if it
suffering
comes, Lord, we will be
can
happy.
be compensated by both of them. You have your remedies.
We are in court.
Yes.
We are in court fighting loggerheads. We are
With
going
regard
there.
to Mr. Banerjee's submission.
One thing is admitted, we are co-sharer.
Yes.
So none can say that you have no right at all.
Better দেখান না, whether you can apply for plan. You can apply for plan. And in terms of your lordship's own judgment, Lord, whether
Posing as the absolute
a
owner to get
co-sharer,
the plan. That is
whether
illegal.
what Mr. Banerjee is saying that is perhaps covered by Lord, judgment of Justice Gonen Roy, Lord, reported in 1980 Calcutta, page 17. My lord may have a look at paragraph 7 of the judgment.
Take all this before the civil court, convince them.
That is not for civil court.
That is not for civil court.
It's of plan.
Lord, whether
And co-sharer can apply. No, co-sharer can apply.
Lord,
for
there is a
I am not acting
The
so far as the
order-
stay is
order-
concerned. I will not
The
do
order
anything.
which has been passed by the officer concerned additional municipal commissioner, that speaks for everything, my lord.
Because of which anyone can apply.
The order,
Order is kept in abeyance,
Exclusive right of order.
right?
the Bengal minister.
Everything can.
Are all there.
Can you not take once, my lord? Why I am saying, my lord?
Bengal municipal act.
হতে পারে না on the face of this order.
Order reject.
দরকার নেই।
Whatever reject. The order, there was sanction plan. Sanction plan cancelled.
Cancel তো হতে পারে।
Cancel তো হবে না, cancel তো করেনি।
Paragraph 34. Paragraph 33.
আরে আমরা পজিশনে আছি,
Painting, দরজা লাগাবো,
পজিশনে আছি।
Paragraph position.
এটা পারবো, সেটা সেটা পারবো।
Order of status quo is at page 52.
ঢুকতে তো দিচ্ছে না।
Page 50 দেখতেছি, একটু শুনুন।
Why am I saying it?
তো হয়ে গেল মুভ করছিস বাড়ি যা
Reason I am saying it. May I read out? In circumstances, the court cannot permit Dr. Atiya Sabha Ahmed to proceed with the construction work at the suit premises which may give rise to irreparable loss and injury to Shanundi and other alleged co-owners if the
Contention.
is found to be true,
Kushan Nandi is who?
with the writ
11.
petitioner of item 11.
Item 11, my client. I'm one of the co-sharers, my lord.
He is son of whom?
Pritish Nandi.
Pritish Nand.
Not before me.
Is my lord is at 15?
No.
Release করছে, release করছে।
Related to me.
Please, can I?
Pritish Nand's ছেলে নেবেন।
He is related to me. I can't hear this.
Please, cholo on.
Kushan Nandi.
So Bengali person can be related to my lord?
Sir, he is closely related to me.
Closely. So if I have a matter, he will not
My
take up.
in-laws brother.
My lord will not take up.
Can't hear
এই
this.
জজ সাহেবের আত্মীয় বলছে।
না, না।
হ্যাঁ।
If I move any matter or personal matter, my lord will not take up. We are also related closely.
No, this is actually related.
Oh, we didn't
My
know.
own sister-in-law.
No, we didn't know.
Sorry, my lord.
The petitioner.
Did not know that, Lord. Did not. We would have.
I just looked at it. I mean, I had no idea. I
The
just
lordship would have passed it on.
thank you very much.
The petitioner.
We did not know, Lord. We would have.
I had no idea.
How you can know?
Even I would have not imagined this.
We didn't know. That's all right. That's all.
Fine.
So 11, 15, both is.
When we sit here, you know, God helps us.
Ah.
But this is a good ground for releasing. One incident for releasing one story. May I told you, lordship? This is code number. Yes, this is the code number 3. Justice Somenwar used to sit in this court.
সমীর মুখার্জি
Division bench. I was moving a matter on order 41 in respect of a promoter. After looking at the paper, Justice Mukherjee told me very soft, very soft.
Yeah.
Seldom seen him angry. The boss, I cannot pick up. And what happened was Person is known to you, to my lord. No. Then now kindly hear, Mr. Basu, this property is in my neighborhood. I used to play football in my childhood days on that property. So how can I take up this matter? Hello, my lord, this is a good ground. I will not play. This court, in court number 3.
Thank you for pointing it
Well,
out.
can you release it so that
Sorry, my lord, excuse me.
No, I had no idea. It would have been very unfair if I would have heard it.
11 and 15 both released.
kindly release it to place before the Honorable Chief Justice for
The matters are released from this bench. One person.
my lord is trying to save himself from me. That's why this has been.
No, not at all. Mr. Basu, not at all.
No.
I had read the entire file.
By this
I
time,
spent so much time.
by this time, my lord has known me. Chal.
Grateful, my lord.
Item number 7.
He'll have it tomorrow.
But Lordship, what has happened,
Oh,
Lordship,
item
I
number
told
7.
him that corporation people are coming, they are still waiting, they are going to demolish it. That is the problem.
Yes.
my lord.
No, that
Can it be
entire, for 5 to 6 times, it has been already division bench order, everything is there. Unless we, entire building is unauthorized, entire building.
But
4 floors. Now they are coming with occupants and occupants are filing the writ petition, taking some time that I will self-demolish. I will vacate. These are going on. That I can show. If your lordship takes up.
But Mr. Banerjee, you have to give them an opportunity, the occupants also. They are the owners of the flat.
Already occupants came.
I
Occupants came and taken time. By 5 to 6 times the occupants came, that I can show. And they have taken time that by 4 months or 5 months I will vacate, but they have not vacated.
So I stay at the portion which is authorized. According to me, Lordship, there is a sanction plan till G+2. G+2
No
which is
sanction.
mentioned in the cell deed. Sanction plan mentioned in the cell deed. On the basis of that, that has been.
Sir, sanction plan mentioned in the sale deed is a different thing. Sanction plan, whether it is there or not,
It is
the
there.
corporation will tell you.
It is there. That's why it is there in the cell deed. Otherwise, it's let the corporation. Otherwise, Lordship, my client will go to jail. He says
Sir,
it on affidavit, my lord. I cannot.
Are you taking
He is ready to go to jail. Otherwise, if he
tomorrow?
Tomorrow, Lordship, if Lordship, this should be settled.
But come with the
I
instructions.
will come with
If he makes a
entire
false-
order sheet.
false statement,
Especially this
I will entire
202.
I will come with the
Entire order sheet and 202.
Yes.
That is what he says, that he is occupant of 202. Flat number 202. Just identify that he
This
has.
person is not filing. I'll buy 4 to 5% being an occupant of the said premises.
You just, if the entire,
I'll come with entire.
if the entire building is illegal,
And don't do it today, sir. Don't demolish it today. Demolish it tomorrow if you find. Lordship,
What university this is going?
only tomorrow, my lord is fixing it.
tomorrow we are fixing it.
Please don't do.
Lord, I'm for the petitioner.
Yes.
Lord, here, Lord, there is a joint venture agreement. Pursuant to that joint venture agreement, my grievance is that in respect of the property that was, my lord, given to develop was, my lord, 4 kathas of land. In, my lord, I have an adjoining land also. I am the owner. The promoter, my lord, in excess of 4 kata have constructed in excess 13 chitaks and 34 square feet, which amounts to 619 square feet extra. So, my lord, your lordship knows if it is a joint venture agreement by virtue of a power of attorney.
Client is very greedy.
Lord, I also ask, Lord,
You
your
came from Bangladesh. You occupied a land. Government under a scheme gave you the land. You became the owner. Owner of 4 katta. You had occupied 5 kattas. Right?
That is, my lord, I am not on. But the
I know,
agreement, my lord has read the brief, my lord, kindly, my lord. I'm sorry. My lord, the construction that has
Read
been.
never ends.
I ask the same question, Lord, what fallen from my client's side, Lord, may I just, Lord, express myself. My client said, look, sir, since there is an execution of development agreement come power of attorney, tomorrow the municipality will say, I am the person responsible. Because whatever that has been done by the promoter by dint of a power of attorney. So I, being a principal, I will be held liable in future. I say it is your own property which will be affected by this complaint. He said, but sir, in future, if someone made a complaint, I will be held guilty because promoter will wash out his hand. That is what fallen from my. I made a detailed representation. Let that be considered. I am not asking for anything more.
Lord, from the page 20, lordship is fine. Page 20 of the writ applications.
Page 12.
Page 21.
21.
They claim to be owner of 4 cutters of land.
That's right.
Entered a development agreement, sanction plan on the basis of that particular development agreement. Constitution was made. In terms of development agreement, petitioner got their respective flats and started enjoyment of the possession of the flat and got also possession certificate that have been annexed and got their name mutated in the municipality, started municipal taxes. Now, from the statements made in writ applications, the encroachment allegation encroachment has been made in respect of the adjacent land, which is not their land. So adjacent landowners, they can make a complaint against us that you are occupying our land, but this is not the case that we have encroached the property of the petitioners. We have constructed according to the sanction plan, delivered their allocated flat.
You for the builder?
Developer, 4 and 5.
Developer. Who's for the corporation? Which corporation?
Khordha municipality, my lord.
Serve them again.
Yes. But the affidavit of service, my lord.
Encroachment.
Please the record, I shall.
Allegation encroachment cannot be
Affidavit of service, you keep it, serve them again, we'll have it.
There's
no urgency.
Diary do have the mentioning of name who usually appear in Khordha municipality, so that it will be. I can give him direct.
Just see in the list. Just see in the list if we have any lawyer for FDR. Kaushik Rai. Give the number to him.
Take down
the number also.
6290.
My responsibility before lordship's allegation encroachment cannot be subject to writ application.
141.
Encroachments.
I will not get into it, but let him come. We'll see.
About
Not today.
302184.
Just
I will inform.
you'll have it on.
My lord, without a notice, matter has been updated. My lord, make it not this week. My lord, I have to prepare myself. But without serving a notice, my lord.
You have to prepare nothing.
We
We prepare ourselves in 1 day. You prepare 1 week.
On Monday, I shall do this.
We prepare in 1 day. You need 1 week. Why? Either we have it on 28th or we have it on Friday.
Friday, my lord, I will not be here.
Then we'll have it on 29th.
29th.
Yes. Not today, 29th.
29th. I'm ready.
Manoj.
We'll do that, Your Lordship. And if Your Lordship require the affidavit of service to be taken on record.
Learned counsel for the petitioner seeks to file a supplementary affidavit bringing on record the birth certificate issued by the Havra Municipal Corporation. Full stop. Let the same be done within a period of 2 weeks, 1 week,
1 week, Your Lordships. We'll do it in 1 week.
within a period of 1 week, with advance copy to the respondents. Affidavit of service is taken on record. Let this matter be listed after on 30th of July.
Lordship, matter is returned.
30th of July.
20th of Grateful.
30th. 30th.
Affidavit of service, if it can be taken. on
Affidavit of service taken.
Grateful. Obliged.
Malad, in item number 14, yes, there are 2 applications for addition of party. These addition of party applications have been filed on behalf of the persons who are similarly placed like the petitioners. Now, the grievance of the petitioner is that the corporation road lane, which is used by the petitioners, has been unauthorizedly obstructed by a construction, Lordship. That is the grievance, Lordship. I have made representations, and Lordship, I have annexed the copy of the representation in the CAN applications. Lordship, kindly come to page 42 once. They also say that they have received my letter. Lordship, page 42, in reference to above mentioned letter, you are requested to submit all documents related to ownership details along with the land deed of the mentioned holding, the complete site plan showing all full address. I have given it, Lordship. Then I have submitted it to the assistant engineer survey. Submission of the documents for road encroachment on behalf of the query letter number such and such. I have submitted, Lordship, and nothing has been done afterwards, Lordship. This has to be considered and corporation need to.
Is 37 of the firstly road, boundary, the permissible 5 foot. Or in public buildings, it is 8 foot maximum. Secondly, my lord, in the representation, page 37. My lord may seize page 38. Section 160 of the Havra Municipal Corporation Act. What it says? They say that Section 160 specifically provides the powers to HMC to take away and remove any encroachments or obstructions on public roads, ensuring their clear use for the public. The illegal wall on the public road is an encroachment that obstructs the lawful use of the roads and prevents me from exercising my legal right of easement. So 160 does not say so. Let them show from the section itself what 160 says. My lord, now I am coming to 161. That is the next page. 161 of the HMC Act grants HMC the authority to take prompt action when the obstruction occurs on public roads. Let them see 161 from the.
This happens.
My lord, please seize the
legal language.
My lord, please seize the book. I am placing 160. I am placing 161.
This happens when the layman writes the legal language by using chat.
I'm asking myself, my lord, whether
that's the result of that. I have also found it, my lord. That's why, Lordship, in a nutshell, I made my grievance, Lordship. Let it be considered by the corporation.
Considered what?
And let the corporation take it.
Made a false interpretation of the statute itself. That I am saying. As an advocate, I must.
You are an advocate.
I bow down. I bow down.
Layman
when your lordship says this, I have nothing to say. But I can show your lordship this.
They become so much
to be done by a lawyer.
These are over anxious litigants who interpret the law.
I will have.
And nowadays, Lordship, another problem because of the AI, the chat GPT. Everybody is writing, they are getting the full detail, complete enumerations.
They should be
we are required to draft it, but it is already drafted.
I am sure that it is drafted by an advocate, but they should be careful. My learned brother should
I agree.
Advise his junior to take steps regarding seeing the section, not to interpret a section in such a manner. It is completely wrong.
They come after
Beside his representation.
I will. I shall.
They come after giving the representation to your office.
Representation?
শেখাতে হবে আমাকে ঠিক করে বলুন তো।
You are,
I am for state, my lord.
and who's can?
My lord, can for my on behalf of two of other clients, Gauri Roy, who are also the neighbors of the same locality.
Both
let
the
them-
cans. Can 1, can 2.
Let them file a fresh representation at least. But this type of
That case,
statement-
I will submit. If they require that, I will.
Yes,
I understand the
This will completely
complexity of my
This will
You
completely
file,
confuse.
don't file a can in this.
You kindly dispose it of.
No, you withdraw these cans, you withdraw.
I will withdraw.
Learned counsel for the petitioner seeks to withdraw
Can
can 1 and can 2.
Additional
Full
petition.
stop. The petitioner, writ petitioner, the petitioner has referred the present writ petition being aggrieved by the inaction of the respondent in not removing the boundary wall which has been erected on the backside of the petitioner's premises situated at 63/5, Tantitara Lane, TS Shibpur, now Chatterjee Hart, District Havra, in such a manner that it blocks the ingress and ingress of the petitioner to the municipal land. It is the case of the petitioner that she had purchased the premises in question via a registered sale deed dated 19/9/2023. Full stop. While purchasing the said land, the backside of the plot that while purchasing the said land on the backside of the said plot, there was a 15 feet, 12 feet common passage. However, when the petitioner visited the said plot, recently, she noticed that a boundary wall has been constructed in a way that obstructs her ingress and ingress to the said common passage. Full stop. The petitioner has preferred a representation dated 7/3/2025. However, no action has been taken by the respondent on the same. Learned counsel for the respondent submits that corporation submits that Mr. Sandeepan Banerjee submits that he is ready and willing to consider petitioner's representation dated 7th of March 2025. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. In view of the statement made by the counsel for the parties, this court directs respondent number. Which respondent, Mr.
Three. Lordship, respondent number 2 is the corporation. Respondent number 4 is the commission.
Who will decide, Mr.
Decide the case. This should be commissioner, Lordship.
No, assessor collector.
Assessor collector cannot.
Tax করবে তো assessor
Commissioner or anybody.
Commissioner or delegate.
The respondent, Havra Municipal Corporation,
My lord.
to decide petitioner's representation dated 7th of March 2025 within a period of
6 weeks.
8 weeks. Within a period of 8 weeks
This was
from the date of communication of this order, in accordance with law, after affording an opportunity of personal hearing to the petitioner as well as any other stakeholders. There is no private respondent here.
There is no private respondent.
Any other stakeholder by way of a speaking order. With the above direction, the present writ petition is disposed of.
well.
Brief level.
I'll be back in 5 minutes.
deep level is
Okay.
16 রাখবেন তো 16 তো 15 তো হয়ে গেল 11 and 15 both released. May it please your lordship, my lord. I appear for the petitioner. My lord,
I'm
I
appealing for
have-
the private respondent. my lord.
but I have flagged an issue before my lord that my lord in a lord joint property in an undivided property, whether one co-owner could get a plan sanctioned without the consent of other co-owners, my lord, according to my understanding, the law says in my favor. I will just quickly show your lordship that the property is undivided from my document, from their document. Lord, kindly take, Lord, two documents from the writ petition. One is at page 18, that is my title deed, of which I have not prepared a typed, Lord, translated copy for my lord. Kindly take this because that was filed in Bengali. তুমি তো বাংলা পড়তে পারো, তোমার চাই? Lord, the schedule, আমি তো তুমি নয়। The schedule, my lord, is at page 25. That is in Bengali. I have given you lordship the translated copy. Kindly have a look at, Lord, the translated copy, internal page 7. What I purchased is, Lord, District North 24 Parganas, PS Rajarat, Baguihati, ADSR office, under Newtown, Ward number 12, Bidhannagar, Jhautala, Swanso, Touji, JL number 10, Touji number Swanso, under present owner, West Bengal State Government Office on behalf of Learned Collector, West Bengal, having our possessor, right? CS Khotia number 53, current 49, LR survey recorded in Ghotia number Swanso, land in Dag number CS 155, current RSLR Dag number 156, 157 Sali land out of 40 decimal, 0.6662 decimal. So what is important here is, my lord, CS Dag number 155, RS 157. CS was then made RS, my lord, the plot number changed. I purchased out of 40, 0.666 decimal. That's my title deed. My lord, then kindly, my lord, take my record of rights.
This is deed of
gift. Deed of gift from my predecessor.
For my father.
From my father, father gifted me.
Father gifted you
Yes. Now, my lord, kindly take page 37 for a moment. Eta dhoro ekটু. Page 37, I have given lordship a translated copy. Lord, kindly have a look at, Lord. My name is recorded, Lord, Mohammad Sabir Ali Mondal, that your lordship will get in, Lord, entry number 4, details of the owner, and kindly see the area out of 40 decimal, 0.662 I purchased. Kindly got that? So I purchased, Lord, or my predecessors, they have given me gift of, Lord, an undivided portion of the property. Now kindly take their document that they have said, Lord, they have also kindly take their opposition. Page 10 onwards, I have given you lordship a translated copy. They have also not filed translated copy. I have prepared. Kindly take, Lord, on the left hand side, plot number, RS plot number 157, Malaras kindly got that. Now out of 40 decimals, they have purchased 0.275. Then kindly turn the page. This goes from page 10 of their opposition till page 15. But I have calculated, they have total purchased 2.2, 3.3, 5.4, 7.4, 9.5 decimal of an undivided property. Now, my lord, when I got to know that they are making construction, Lord, I lodged a complaint to the municipality. Kindly come back to my writ petition for a moment. I'll give you, lordship, 2-3 dates. Lord, I lodged a complaint, then nothing was being done. I filed a suit. I filed a suit for declaration and injunction that I am the owner. Lord, the trial court granted me an injunction, page 42. Kindly comes. Kindly mark the date, Lord, 8th February 2024. I got the order of injunction, page 42. I got the order of injunction on 8th February 2024. Reply to them. Now, if my lord takes my reply for a moment, affidavit in reply that I have filed.
Yes.
ওই যে টাইপ কপি গুলো করেছি বাবুদাকে দেখিয়ে দে, চেক করে নি ঠিক ডকুমেন্ট করে। দেখে না ঠিক ডকুমেন্ট কিনা দেখে না ভাই।
Yes.
So now kindly take my reply for a moment. Lord, in my suit, I got a commissioner appointed. They have annexed that order in their opposition. Lord, I am not taking your lordship because that's an undisputed position. Kindly come to page 24 of my reply. I have given your lordship the date of the injunction 8 February 2024. Commissioner was appointed by order dated 18th April 2024. My lord may take note of that. But kindly come to page 24, the report of the commissioner. My lord kindly got that. Lord, kindly see second paragraph. In my notice, I have been mentioned the date on time of local inspection so that the date and time was fixed on 22nd May 2024. That's the date of inspection. My lord kindly got that. Now kindly see what he is saying. The next page, only one line I'll place. On that day, I reached the suit local. After reaching there, the plaintiff and the learned advocate for the defendant and learned advocate for the defendant personally present at the time of. Thereafter, the plaintiff and the defendant identified the suit property in his personal capacity. So suit property was identified. Kindly turn the page, page 25, the report. As per point of inspection, I inspected the same accordingly as per the point wise below. Yes, there is an incomplete Pakka construction consisting G plus 3-story building. So on the date of inspection, the construction was incomplete. That's coming from the commissioner's report. But kindly take point number 2. Yes, there is some building material lying over the suit property like sand, bricks, stone chips, iron rod. 3. Yes, there is some construction was going on over the suit property. My lord need not go into the detail. Kindly come to 4. Suit property is now under construction and some masons are working in the suit property. So as on 22nd May 2024, the construction was going on. There was an order of injunction. This is the facts of the case. Now let us see the law. What is the law? My lord will kindly take for a moment the West Bengal Municipal Building Rules 2007. Because Vidhannagar Corporation, although
See, the other part of the property belongs to your relatives.
yes, there is no dispute about that. They don't say that I am not the owner. They don't say that they purchase the entire property. They say they purchase only a portion of the property. Now, kindly have a look at the law.
That is disputed question of fact.
No, there is no dispute. They don't dispute my title. They don't dispute their title. They don't say they purchase the entire 40 decibel. Undivided property, one person cannot get plan. That is the law. I am on that only. Lord, it is his own case. From their affidavit, I will show that they purchase only 7 decimals. Had it been a case that they purchase 40 decimals, I would have not any case. Kindly have a look at this. Just have a look at this. Then next. Lord, Vidhannagar Corporation is a corporation which is governed under West Bengal Municipal.
On the other side.
West Bengal Municipal Corporation Act 2006. Lord, under section 361 of the Act, Lord, they follow this building rule. But kindly come to Rule 11. I have flagged those 2 pages. Kindly come to Rule 11. Kindly have a look at, Lord, what is the requirement? No person shall erect a new building or re-erect or make addition and or alteration of any building or cause the same to be done without first obtaining sanction in the form of building permit from the Board of Councillors. Notwithstanding the provisions of sub-rule 1, no building permit shall be required subject to consideration of structural stability, safety, said building as well as adjoining structure responsible owner for the subject. Then kindly skip over, kindly come to 3. Next page. Every person intending to erect a new building or make addition, I am relying on 3, addition and or alteration to any new building shall apply new building shall apply for sanction of giving notice in writing in form B attached to this rule along with the following. Not along with the following. A. Application shall contain in addition to the notice before aforesaid the all declaration will kindly take B. Copies of documents showing that the applicant has exclusive right to undertake such work. So when I apply for a plan, I'll have to submit a form B along with document that I have the exclusive right. Not this word exclusive right I'm relying on. I purchased a portion of a property. I go there, get a plan without disclosing that I have an exclusive right. Now, Lord, kindly come to form B, which is flag marked for your lordships. Kindly take form B once. That is mandatory. Kindly take form B. The second flag. Not kindly see holding number, entry number 3 is name of the owner. So you have to give the name of the owner. Then 4, status. Owner authorized by the power of attorney others. So only an owner or anybody authorized by the owner can apply for a plan. Then my lord, kindly turn the page and come to clause number 17. Proof of ownership, whether it is deed of conveyance, gift, lease, record of rights, orcha, partition, exchange, will and probate, and other document and mutation certificate issued by the municipality. So when someone goes to apply for a plan, he has to show 2 things. Firstly, that he has exclusive right to make construction, and a form B, where he has to submit the ownership document and record of rights. He must have submitted his 3 deeds, which he has relied on in his affidavit, which he says that I purchased 7.5 decimals of land out of 40 decimals. He doesn't say that he is the owner of the absolute owner of the entire portion of land. There must have been some co-sharers, whether it is me, X, Y, Z. He is not the owner of the entire land. But until the land is partitioned, he has a separate premises number. But he doesn't become the owner of that particular parted bounded portion. But the statute says only an owner who has exclusive right to make construction can get a plan. Now there is an order of injunction. There is a suit filed. Now I'll now show that what is his case in the opposition. Can you take his opposition? Paragraph 7. I am not raising any disputed facts. It's his own admission. I'm showing, my lord. Page 3, para 7. That not kindly take in this regard, 4th line, para 7, page 3. Kindly got that? In this regard, it is stated that the added respondent is a joint owner of a plot of land measuring about 3 kata 14 chitaks 10 square feet, comprised in Dag number CS 155 LR 1557. But then kindly skip over 2-3 line. Rajarat upon the said plot of land being transferred white registered deed of conveyance dated 24th November 17, registered in the office of the ADSR, so and so, jointly executed by Suprakash Chakraborty, Suprabhas Chakraborty, Sulekha Ghoshal, whose ownership has devolved through their mother, namely Chaya Chakraborty, who in turn had acquired the said plot of land by registered deed dated 14th December 84, registered in the office of ADSR, Salt Lake. Then kindly take the next paragraph. It is further stated that added respondents are joint owners in respect of another plot of land, 2 kathas more or less, plot number 157. So 157 they have purchased in 2 tranches from 2 different persons. Then kindly says CS number Khotian, RS number, then kindly from registered deed of conveyance, office dated 18th April 2018 date. It is further categorically stated construction of building has been undertaken within the limits of the aforementioned plots. Lord, if you cannot get a plan in an undivided property, how would you know that you are making construction in either 5 kata or 6 kata, 7 kata? Law doesn't entitle you. Lord, the law is very clear that only the owners can apply for a plan. If a plot is 10 decimal, if I own only 1 decimal, I cannot apply for a plan. Lord, I will rely on only one judgment on this subject. Kindly have a look at this. Kindly, it is para 21. Not kindly take this block. Now this is reported in 2003 to CLT, page 588. Kindly come to this is the division main judgment of your lordship's court. Lord, kindly come to paragraph 19. It is therefore evident that only a person who is entitled to claim right of all enjoyments and benefits of the property, along with somebody else as also claims possession in respect of every inch of the property, would be a co-owner relation thereto. A person who has only a proportionate share of a land over which the flat has been constructed and some rights for common use, which incidents are normally found these days in respect of ownership of apartment cannot be said to be a co-owner except in relation to common passage. It has been, then kindly take para 21, section 2072, 210A, 210C, West Bengal Municipal Act, and the relevant portion of the Rule 13 and 14. Rule 13 is now Rule 11 of 24 Municipal Act, and Form B is relevant for the purpose of the case. 207, the Rule 13 is quoted. Kindly then take note, Form B is quoted, then para 22. If she is not a co-owner, the requirement of filing joint application for sanction of building plan as envisaged under the provision of West Bengal Municipal Act, in particular those provisions which had been quoted supra, are not attracted in this case. Not had Mr. Mukherjee's client is not a co-owner, it would not have come into place as per this judgment. His opposition, his record of right says he has purchased a portion of that plot. He is a co-owner. He could not have applied for a plan. But the municipality sat tight. There was an order of injunction. He constructed in violation of the order of injunction, and municipality has favored him with a completion certificate. Page 16 of the reply. If the plan is illegal, then my lord, everything is else what has been done is illegal. Anything done in violation of a court's order, my lord, is a nullity. My lord knows that, my lord. I am carrying one judgment, my lord. I need not cite this. This is, my lord, 1999 1 CLT 149. But this is a settled law, my lord. I need not cite this, my lord, that anything done in violation of a court's order. I filed a suit. I got an order of injunction. You applied for a plan without disclosing that you are not the absolute owner. But kindly, only it's my humble, Lord, I beseech you, lordships, kindly inquire from the municipality whether what was informed to the municipality. As far as my, Lord, knowledge, I had appeared for this municipality, Lord, for quite some time previously. I know the system. They would not have even accepted the plan if they had known that it's some, Lord, unpartisan property. He is not the absolute owner. As for the system that I knew, now I don't know what is the system they are following. Lord, kindly inquire from the municipality whether they have disclosed that they are not the absolute owner 100% of the plot. Number CS 157. That's my case, my lord, that the plan could not have been sanctioned and you have violated the court's order. You made a construction, you cannot claim any equity. And if the plan is sanctioned wrongly, then it has to be demolished. And I got an injunction. I prayed for police help. That was rejected. They have played a case that since I could not get a police help, I should not get this. But these are my submissions before lordship. Lord, the law says you must have the exclusive right to undertake construction. Now, if this is not today allowed, kindly, Lord, do not take me otherwise. What will happen is one person will come in a big property, get a plan, start construction without having an exclusive right. The legislature was very much conscious about this. That is why Rule 11 Sub Rule 3B is there. That you must show exclusive right. And his record of right says he is not an exclusive owner. His affidavit says he is a joint owner of that plot, a portion. These are my submissions.
Yes, Mr. Nag.
But so far as the co-ownership is concerned, my lord, this application of form, the plan nowadays is through a online portal. In the online portal, my lord, they have to fill in all the details, put in all the requisite documents, my lord. So far as my instruction comes, my lord, it says that the land, there is a allegation that is a Shali land which has been given, but my lord, the record which was uploaded shows that it was a Bastu land. So we had gone by that. And my lord, primarily, my lord, though I should come back with a report to assist my lord on the point that whether the co-ownership point had been disclosed before the municipality or not, my lord. But it appears, my lord, that I don't have the documents which has been provided to me, my lord. We does not speak specifically on that point. But my lord, if there was a position of co-ownership declared, then they have to make a joint application. That is the law. I am not denying that effect. If they have not done that, whether the title is with them or the title is with them, we do not know. But if it is a co-ownership property, perhaps they have to apply jointly. And the online application has to be like that only. If they have not done that, then that is not in the.
Look into it and cancel it.
Lord, we will.
May I just indicate?
No. We will, man, upon verification, and we will.
May I just indicate? Kindly see once the writ petition. Kindly see once. But someone came before your lordship court but what he has stated in the writ petition and what he is arguing before your lordship, but kindly straightway come to but the writ petition at page in the writ petition, what is his case make out, but kindly see page 5, paragraph 7 and 8.
Yes.
Now, my lord, what is his allegation? Your petitioner states that ever since the said development work commenced, the construction has been carried out without maintaining proper norms and regulation, in as much as the proper open space on either side or at the back portion of the disputed property has not been left for easementary right or otherwise. This is number 1. Then see page paragraph 8. Your petitioner states that the said construction work is being carried out deliberately violating relevant provision of the West Bengal Municipal Corporation Act 2006 and its allied building rules and regulation, and despite of several requests, the illegal encroachment and illegal extension. Therefore, his case made out in the writ petition is without leaving any side space and encroachment. Now, what is his locus? What has been stated in the writ petition? If your lordship kindly straightway come to his complaint, but before filing of the writ petition, someone has to make a representation. Here, no representation, lawyer's letter. Kindly turn to page 44. Page 44. But kindly see page, straightway come to page 46, paragraph 4. That on the adjoining side of the property owned by my client, therefore, he has to restrict his submission. What is the representation made by the landed lawyer in the municipality? In one hand, he is saying he is an adjoining landowner. Now, my lord, what he has done? Now, my lord, he from the beginning tried to, my lord, I should not say in open court what is his actual intention. Now, my lord, if your lordship see how he derived the title, he is saying that he got the property from his father by a deed of gift. Now, my lord, in the deed of gift, he got the property. Then what is necessity to file a civil suit stating a declaration that declare I am the owner? Kindly straightway come to the prayer in the plaint. If your lordship kindly straightway come to the plaint, which I have annexed, my lord, in the they have also annexed in the reply. But if your lordship opposition reply to the but kindly see his reply, my lord, in here, my lord, he annexed the, my lord, the plaint, page 16 of the reply, my lord, affirmed on.
Your reply? Your reply?
Their reply. Initially, they have very cleverly stated in the writ petition a civil suit is pending. Now, when I pointed out about the civil suit, they annexed the plaint. Kindly straightway come to page 16. Who is the plaintiff? Sheikh Sabir Ali, Muhammad Sabir Ali Mondol, who is the petitioner before your lordship. Now, my lord, kindly straightway come to page 17. How he derived the title, that is confusing. And may I read for your lordship? That the property measuring about 40 decimals of land of CS Dag number 155, present RS LR Dag number 157, Moja Atgara, JL number such and such. Now, my lord, this way he is derived. Now, if you lordship see paragraph 3, paragraph 2, that since said Muhammad Ismail died, leaving behind him this wife, Elizan Bibi, and one son, Karim Baks Mondol, and one daughter, Golnehar Bibi, as his only legal heir and successor, who got the entire property left by Ismail Mondol according to Muslim Faraj. That after the demise of Ismail Mondol, one Upendranath Dhali purchased the entire property left by Ismail Mondol from his son, Karim Baks Mondol, and wife, Elizan Bibi, only leaving behind Golnehar Bibi and daughter of Ismail Mondol, fraudulently by making forged document and suppressing material fact, though Golnehar Bibi and the daughter of Ismail Mondol and Elizan Bibi and full-blooded sister of said Karim Baks was alive at that point of time. Now, my lord, your lordship will find kindly straightway, skipping the subsequent paragraph, paragraph 6, that while Shaukat Ali Mondol and 4 brothers jointly started to possess and enjoy the property measuring about 13 decimals of land, other portion of the Suddag obtained by the deed of Heba Bil Ewaj, one Bibhuti Dhali and some others came to dispossess Shaukat Ali and 4 others from the suit property and other properties illegally. And thereafter, my lord, a story has been murdered, a suit has been filed, and ultimately, this Shaukat Ali and 4 others become the owner of the property.
and this petitioner has obtained a particular portion from his father. Now, if that be so, now what he has stated in the plaint, what is my status? Paragraph 10, that I am nothing but I am a hooligans. This is my status. Then if that be so, then what is the necessity for paying this relief, page 21, for a decree of declaration that the plaintiff is owner and possessor of the 2.648 decimals of page 21. I have what it. For a decree of declaration that the plaintiff is the owner and possessor of 2.648 decimals of land within the entire suit property. Therefore, he is also in confusion whether he is an owner. He sought for a declaration before the civil court, that is sub judice. Now, kindly see the next prayer. Now, if you see, but here he has annexed suit the plaint, but ultimately what he has stated, he is also confusing. But if you see the prayer, second prayer B, for an order thereby restraining the defendant from making any construction over the suit property and from disturbing peaceful possession. Therefore, whatever my right, title, interest, no declaration, no cancellation, nothing. He is not even admit I am a co-share, or now what the pleadings, what the submission is Mr. Chakraborty is making. On the contrary, what is the your lordship knows before filing of the writ petition, there must be a representation intimating the corporation. Kindly see the first letter of intimation, although not by the petitioner, by a learned advocate, when 23rd February 2024, starts at page 44 of the writ petition. And in the said lawyer's letter, what the status he has stated, he is nothing but an adjoining landowner at page 46. Therefore, now what happened after filing of the suit, your lordship, they filed an application for injunction and ultimately obtained an ad interim order of injunction. We entered appearance. Now, we entered appearance, we filed all the documents, that we have a sanction plan and everything. Very cleverly, he did not make the municipality at a party in the suit. Now, what happened? Then he make out a story that he has been dispossessed. Now, I think Mr. Chakraborty should not make running comments. Now,
Let him say, I will answer that. Why are you listening to me?
Now, what happened thereafter? He ultimately filed an application for police help, saying that I have been his possession has been disturbed. Learned trial rejected the same. Now, kindly see against that he came up before this court. But the finding of this honorable court, kindly see in a revisional application that I have annexed in my revision in my opposition if you lordship kindly straightway come to my affidavit in opposition. My order at page 8. No, I'm sorry, not page 8. Just Madam, I'm sorry, that has not been annexed, kindly, because this order has been passed, but subsequently before affirmation, see, because Mr. Chakraborty's client was there. Now, if you see, there is police self applicant has been turned down. Against that, his client came up before this court. Now, this honorable kindly see the next second page. There is a specific finding of the trial judge as well as of this honorable court. He is not in possession of the property. Now, what he has done, when he failed and ultimately tried to raise or obstruct all my construction and everything, now he is filed his writ petition. And what is his prayer? I will show. Kindly see, there is a specific finding subject to lordship correction. That however, the learned trial judge found that the plaintiff is not in possession. If you lordship see that. Yes. Now, what this honorable court directed the injunction be disposed of within a very short span of time. But I will show from the order sheet that with the help of Mr. Chakraborty's client, that has not been disposed of. Now, what he has done, now he is in one hand claiming before the court below to declare his right title interest over the property, to declare that the if you see once again, but the prayer of the plaintiff, he is asking declare me that I am the owner of the property. In representation, he is saying I am the adjoining owner. In the writ petition, if you see the entire writ petition, your lordship will find nowhere he has stated, or the allegation in the writ petition is twofold. One is common, your lordship knows. I made a complaint before the corporation. Where is that complaint? The complaint is of the learned lawyer in 2024 when the civil suit is in session. Now, second thing, what happened? In the writ petition, he has stated normal common ground that air and light has been blocked Second thing, encroachment. With due respect, encroachment matter already civil code is in session. He can, what is the prayer he has stated? Now, if I put this question to myself, can he parallelly proceed to, in both way? In one hand, in the civil code, he is asking for restraining me from making any construction. Then he filed an application of a police cell. That police will see that no construction that has been turned down, affirm up to this honorable court. Now, temporary ad interim injunction is yet to be disposed of. Now, before your lordship court, what submission has been made, that is not the pleadings. A person has to make the submission, whatever he has stated in the pleadings. In the pleadings, if your lordship see the submission which Mr. Chakraborty has made, that he is a co-sharer. But so far my understanding, I read from the writ petition, I could not find. The prayer, if your lordship see, the prayer is, if your lordship see once, page 7, paragraph 11 and...
Sarji, don't you think that the corporation should file its report?
Now, the question will come, what the corporation is saying to the municipality, rather. That corporation is saying that I have to verify from the record whether the declaration which I have given, or whether the declaration I have given, I am the co-sharer or not. But if I put this question to myself, who is Mr. Chakraborty to say all these things when his case is in the writ petition and the lawyer's representation that he is the adjoining owner, and he is now claiming to be the owner of the property when civil suit is pending. Until and unless civil court declare his right at interest, he cannot say that he is a co-owner. Number, I purchased the property from some Chakrabortys. Number, how?
Not from me. Not from him, Lord. I cannot give him anything. He is more, 1,000 times bigger than all of us, Lord. Mr. Mukherjee is supreme in all aspects. Nobody can give him anything. We only go to his house and get good food, Lord. Nobody can give him anything. He is supreme.
Now the question is, your
Chakrabortys are mostly poor.
But your lordship, I don't know, I should not say in open court. If your lordship has a Facebook, your lordship will find in 3 or 4 times he used to visit in some places which is not less than in foreign all the places.
Those are AI. Now AI has come. Those are all AI.
Oh my God. Now the question will come whether municipality will file a report on the basis of the submission.
Let the corporation come back with a report.
No question is there. The other co-sharer is not. He is not the co-sharer. He is from his writ petition. He is saying adjoining owner. But if his right at interest has not
been get the stand of the municipality.
Yes.
From the submission made by Mr. Mukherjee, one thing apparently is clear that there is no joint application, or there cannot be application, because the understanding of Mr. Mukherjee's clients is that they are the owners of the property and they are the encroachers.
But if you actually look at the pleading, to an extent, that is what he acknowledges. His pleading is also that I am a adjoining neighbor.
Lord, paragraph 5, Mr. Mukherjee has missed. Lord, he has placed para 7, but he could not kindly come to that page 5.
I'm sure the corporation.
He just could not see that paragraph, Lord. He missed it very conveniently. Para 5. He read para 7, but he could not look up a little up, Lord, read para 5. But that happens sometimes. When you are in a wrong footing, that happens.
Let us see who is in.
That happens. He missed para 5, Lord. I cannot blame him. He missed para 5.
What is Ijmali?
Para 5. Your petitioner states that the entire property of LR 157 is unpartitioned. Petitioner is collecting, holding the said property in Ejmali with other recorded owners. It's an unpartitioned property 157, and I am holding Ejmali with him. That means all of us are co-personers, co-owners of the property. He missed that. Lord, I am raising a question of law. If you have misled,
why you have not filed your reply? You were not asked.
But there was no direction for opposition.
No. The parties have exchanged their meetings.
If you actually see the order of Justice Chandra and Mr. Chakraborty is too clever. Initially, I did not make a party owner. And you see, the addition of party was filed for impleading me. And he is married. He won.
But the answering respondent is corporation.
Not alone we are the answering respondent. I am sure that my records will show that he has applied, saying that he has given.
We'll see that.
So whether he is the owner or not, is beyond our ambit. We will only go by whatever document.
Lord, something which we write today, the difficulty is tomorrow we cannot remove that. In the written statement, what is the case made out by them, we will place that once the report comes. What he has, whether he has acknowledged me or not, we'll come back with that. Let the municipality place the record, Lord, what was stated to them.
Learned counsel for the.
Chakraborty provided us with a copy of the reply he has filed.
Right now we have given, right now we have given. The
Madam, only one submission.
Simani will give it to
only
Mr.
one submission may I just make? Only one submission. Now, my lord, if your lordship permit, my lord, I can file all my deeds where, my lord, a specific demarcated portion has been mentioned. Now, my lord, on the basis of the same, my lord, I applied. Now, my lord, let Mr. Chakraborty shows what is his right in the property. And if, my lord, he has no right of court.
This is not the court.
Then
Not the court.
I'm only looking into the
Yes.
aspect whether the sanction plan has been rightly sanctioned or not.
And your lordship's court has held in many matters that civil court cannot adjudicate on this aspect. It is the writ court which can. Justice Sarkar, Justice Sinha.
There was no direction upon the municipality to file it.
Let it come now. Let
I
it come.
can see that. Learned counsel for the respondent municipality seeks and is granted 4 weeks time, 3 weeks time, affidavit and opposition, file your affidavit. 4 weeks time to file his affidavit in opposition, reply to the same if any with.
3 week, 1 week, not we can.
If, then, my lord, if kindly give us some time to give reply, my lord. I don't know what
I
record
reply.
they will come with, my lord.
Reply I will give. My
No, he will
petition, they will file opposition. Why will
I
you
can
give
file the
reply?
opposition. I don't know about exception, whatever, my lord.
Reply if any within 1 week thereafter. List after 6 weeks.
আজ কত তারিখ রে রূপসা 15/1/2 Lord, 6 will take us to 26th of August.
Yes, you'll
26th
have
of
your independence.
Yes, after Independence Day, Lord will come.
That's why Mr. Chakraborty is not proceeding in the suit.
Very well. We are all said and done. We are extremely grateful for a patient hearing, Lord. Mr. Mukherjee has argued the suit. Lord, জল খাও গলা শুকিয়ে গেছে চলো
File man. ये उसका नहीं मेरा ये उसका नहीं ये मेरा है
West Bengal Municipal Building
Rules.
Great, very much.
He's saying the act. I said no, act is mine. Yes.
Now, the issue is very short. This question of the maintenance and upgradation of drainage by the Calcutta Municipal Corporation. We have been making representations and representations. There's nothing been done. This is basically their statutory responsibility. And to that, Lord, I believe the Honorable Court was pleased to seek for a report from the engineering department.
Yes.
And the report is funnier than anything could be. I don't know whether the report is with you.
The only if you have seen the report?
I've seen the report.
Yes.
I've taken the report says the petitioner made to the executive engineer Borough when department asked the petitioner to submit the sanction documents regarding existing building and drainage system, if any. But the drainage system, sanction should remain with the municipality, not with the building owner or with the occupier.
No, as far as the sanction is concerned, it is with the building owner.
These are all old building, Milord, asbestos shed building. It had no required sanction necessary at the point of time it was done. But this drainage is there. Drainage is the corporation's basic responsibility.
Restoration of drainage.
No, I don't want to not have a new drainage. The drainage which is there is not being properly maintained. That's the issue.
The corporation says that as far as the sanction is concerned, they can't even they can't look into it because this
The corporation is doing something which betrays the statute. That kindly will not takes up the Calcutta Municipal Corporation. This is obligatory responsibility. Under Section 29, obligatory functions of the corporations has been laid down, and drainage is one of the important tasks of it because this has not.
You're reading section?
Section 29
of
Calcutta Municipal Corporation Act.
Please that in your exception, you have not filed an exception.
Yes, I filed an exception.
No.
I already.
Exception has not been filed.
Sorry, but I'm extremely sorry.
Give a copy.
আগে যাওনি কেন? লিভের দরকার কি? কেউ তো সব ফাইল করতে বলেছে।
Let me look into it, my lord.
When do you want it, Mr. Ghosh?
কবে করবে?
Exception filed on behalf of the petitioner is taken on record. Mr. Ghosh prays for some time
হাতে রেখে দেয় কেউ?
go through the,
পারমিশন লাগে নাকি?
let this matter be listed after. Yes.
On Friday, my lord?
2 weeks here.
2 weeks করবে?
হবে না। অনেক কথা লিখতে হবে। সেগুলো আমার ভালো হতো। তুমি এটা খুঁজে বলে ভালো হতো।
Then we'll have any day after, my lord, 20th August, because I'll be busy in the house.
20th August. So we will have it then on 25th August.
এটার জন্য 2 weeks লাগবে তো অবশ্যই ঠিক আছে।
তোমাকে এবার তোমার অনেক উত্তর দিতে হবে।
অনেক উত্তর দিতে হবে। দাও।
Get from us.
Yes,
My lord,
Mr. Das.
not today. Petition.
My lord, on the occasion, my lord,
Paying for not today, item number 18.
my lord, only prayer. My prayer is only not this week, your lord.
Kumar Banerjee.
Not this week. I am not only not today, but not this
Not
week.
this.
Lordship.
Proxy counsel so and so. Wait.
Oh, my lord.
Proxy counsel so and so appeared and states that the who's the main counsel?
Achindo Kumar Banerjee, an advocate on record.
Main counsel so and so is indisposed. Let this matter be listed after 2 weeks.
My lord, get food.
After 2 weeks.
My lord.
When the order is getting dictated, stay there, madam. When the order is getting dictated in your matter, stay. You are leaving before the order is getting completed. Rest of the matters after lunch. We'll call out after lunch.
Yes.
Lord, my learned friend. This one.
Yes.
Item number 1. কি নামটা কি cost item? আমার May it please your lordship.
I'm appealing for the Kolkata Municipal
But the
Corporation.
petitioner, since long, is in possession of a stall in a market known as Orphanganj Cattle Market, along with many other traders. And this is a family business coming since long. That I'm in possession and that I'm lawfully in possession is not disputed by the Calcutta Municipal Corporation or any authority. Lord, in November 2011, I was visited by a notice by the DM saying that I should stop my trade. We challenged that. Ultimately, this Honorable Court, Lord, directed no, you cannot stop his trade. Trade has to continue. And if the corporation is in a dilapidated position, it is the incumbent duty of the state authorities to see that it is made habitable. Corporation or the authorities did not challenge this order in appeal. They sat over it. Then since I'm not doing any trade, but I'm in possession, along with others. Now, my lord, suddenly, this dispute continues. Corporation has not challenged it in appeal. Suddenly, my lord, we are visited with sub 6 June, my lord, corporation personnel come there and say since the adjacent market has been subjected to a fire, devastating fire, we have to take your possession to allot those persons who have suffered losses. Now, this was surprising. We were shocked.
What is the document to show that?
Lord, their visit, my lord, and the demolition. I have photographs of that.
Sir, what is the document you have placed on record to show that you have been asked to vacate or there is any threat?
Verbal, my lord.
On verbal threat, this court can't function.
No, my lord. Demolition, demolition. They came with the bulldozer without any notice to us, and they are still there.
That's a photo of the bulldozer.
Lordship.
That is our case. বুলডোজারটা বুলডোজারের ছবি
Third page.
আরেকটা পেজ উঠে বুলডোজারের ছবি বুলডোজারের ছবি
How do I know this is the area and they have come for you?
Lordship will appoint any officer of the court, my lord, to go and inspect and give your lordship a report tomorrow, my lord. Any advocate, my lord. Lord, and we've got the video footage also. Lord, there are two questions basically. Dispossessing me of my lawful possession and then a threat of demolition.
Yeah. The document which you have placed, annexure P1, page 24 is, I believe, the receipt.
Lordship.
Right? The receipt of, these are all 2011 documents which you have put, 2016, 2011.
Of the edit petition, then.
No.
That is referral of the edit petition then.
Your allotment of the shop.
Lordship.
From where you are carrying on the business.
Page 24?
That's what I'm asking you, which. That's exactly what I said. Sir, this is what I'm saying.
My lord, this market was
That's
under
exactly, that's what I referred to. I referred to annexure P1. That's what I said.
Lordship.
That page 24 is supposed to be your receipt or challan or
Lordship.
whatsoever it is, right? Now, these are documents which pertain to year 2016, 1, and the rest are all 2011.
Lordship.
Now, tell me, what are these documents?
These are the taxes that we pay to the authorities.
These are the taxes which you pay to the authority. Now, as far as the details of, so this is, because these are all in vernacular.
Lordship.
So, I can see Bazaar Naam, Bibran is 17, Tildi, something.
That your lordship is
Malik.
having problem because it's in Bengali.
This little which I can read of
Lordship,
Bangla,
lordship.
I can read little bit. I can't read whole lot of it. Tell me, what is this? This is
The monthly tax receipt of
Raseed.
the- of the-
Raseed.
of the market.
The last word probably is Raseed.
Lord, and
These are all old documents of yours. What is, so this is not in dispute that you are still,
that is not disputed. Lord, and kindly comes to page 35, my lord. They admit my possession. They admit my being there. They admit Justice Talukdar's order that was passed.
And not only that, there is no such cattle slaughtering. It's a cattle market. And Bengal
Lord, the dispute arose, my lord, because
there is a
cattle
main-
slaughtering and trading. We are traders. No, and that is not the issue. That issue has been resolved. They have not appealed against that order. They have not challenged the order passed by the single bench.
Yes.
Lord, now they visit us with bulldozers.
Yes.
Verbally say we have to take your possession
Yes.
and we shall demolish it. Yesterday, when the matter was before the courtroom number 14, my lord,
Yes.
while the matter was going on, when their counsel was appearing, at the same time, simultaneously, they started breaking the door of the market.
Yes.
Lord, let them exhaust the procedure. Let them give us a notice. Let us be given an opportunity of being
Trade
heard.
and business is a fundamental right.
My fundamental right is being infringed, Lord. Let them exhaust the procedure, my lord. If we are out of court, we are out of court. If we do not have a case, if we do not have a case, we do not have
Yes,
a case.
Mr.
But
Kar.
they cannot do this way, Lord.
Lord, this gentleman who's before your lordship, Lord, he has no right whatsoever on the open area, which is, Lord, where, Lord, there is a possibility of shifting, Lord, some of the traders whose shop has been gutted down due to fire. Now, Lord, just for your lordship's information, please come to paragraph 4 of the petition. Lord,
I see this is an apprehension, but you have to satisfy me.
yes, I'll just take your lordship to paragraph 4.
Yes.
Lord, kindly see, he says that his business continued uninterrupted till November 2011. That's the first sentence of paragraph 4.
Yes.
After that, your lordships would not find anything saying in the whole petition that he is still carrying on.
That is the reason there's no document also on it.
Correct. Now, Lord, the document that he has disclosed, Lord, these are some of the rent receipts or Lord, tax receipts, which, Lord, the government had issued to them when this property belonged to the government.
Yes.
Originally, Lord, the cattle trading was permitted on this land. Then in 2011, there was an order passed stopping the cattle trading completely. And then, Lord, they came up to this court and they said that if the trading is not for the purpose of sacrifice, then we should be permitted to carry on. The court directed the authority, the then Lord district magistrate.
I've seen that.
Your lordship has seen the order. Now, Lord, post that, Lord, government never permitted them to carry on any cattle trade there. Number one. Number two, Lord, this property has been handed over to the Kolkata Municipal Corporation.
In 22.
Lord, your lordships will find that in page 37.
2022.
2020, it was handed over. 22, Lord, we gave a notice saying that if anybody wants to carry on business, please come forward, get yourself enlisted. Page 37, your lordships will find that notice is there.
Yes.
Now, Lord, post that, Lord, this petitioner has never approached us.
Yes.
We don't have any records of his carrying on any business because, Lord, cattle trading is firstly not permitted under the Kolkata Municipal Corporation Act.
Yes.
If your lordships kindly, Lord, take the Kolkata Municipal Corporation Act once. Please come to section 519. In none of our markets, Lord, we permit, Lord, any cattle trading. 519. This is, Lord, it says, no person shall use or permit to be used any land or premises keeping horses, cattle, or other so and so animals, parts, sale or hire, etc., without or otherwise than in conformity with the terms of a license granted by the Municipal Commission. He has never, my lord, obtained any license, my lord, from the Municipal Commissioner. Then, my lord, please come to section 520.
Yes. Production of milk.
21, 22, 23, these are the controls, my lord, on animals that we exercise.
Yes.
Now, my lord, so far as this particular petitioner is concerned, Lord, there is one petitioner before your lordship. My lord will find that he has no right or anything, Lord, on the property which is a vacant area. Now, my lord, what happened was very interesting. They put a board and, Lord, closed the gate of this open area yesterday. This is the board, Lord, that they had put. একটা copy আছে? Copy দাও, extra copy আছে? This is the board they put, and they said that this is subject to the result of the writ petition. Now, my lord, Kolkata Municipal Corporation, my lord, lodged a police complaint that it's my property, nobody can close the gate. Pursuant to which, my lord, the police has opened the gate. And, my lord, today, what is happening is that, my lord, it is only the cleaning of the area which is going on. Because, my lord, these people who have lost their shop, there has to be a temporary accommodation to them before, my lord, the market can be reconstructed. This is the purpose, and I can show your lordship some of the pictures. I have brought it to show to your lordship that, Lord, this is a vacant area where, Lord, we are trying to clean up the area. It's full of jungles and shrubs. Your lordships can, Lord, have a look at this these photographs. This is here.
Milk production jungle.
This is here. And not a single license has been produced, Lord, with this writ petition. We are trying to clean up the place.
Bulldozer. Came with bulldozer.
And Lord, there is no dispute that this property belongs to me. And I am not, Lord, not dispossessing anybody. Only one person has come before your lordship. And Lord, he doesn't have any license from me. He is not registered as my, Lord, occupier in anywhere in the property.
Yes.
If your lordship wants, Lord, I can put it on affidavit that, Lord, we don't have any records of his existence in the property. He's a busybody, Lord, who has come across, and Lord, he produces some receipt which the government might have given to him for cattle trading at some point. But then the controversy arose, the government stopped it, and then ultimately they said that you can carry on, but provided you don't put the cattle to sacrifice. Then, Lord, what happens is that 2011 onwards, there is no, even on pleadings, Lord, he doesn't say that he has carried on any trading. So, Lord, question of his rights being affected does not arise, and we are doing it for a public purpose. We are not, Lord, trying to take, Lord, possession and, Lord, put it to some other purpose.
Yes.
There are certain traders who are distressed, Lord, we are trying to help them. This is what the purpose is.
Yes.
And Lord, he has not a semblance of a right, Lord. No right has been disclosed in the writ petition. So, Lord, this needs to be outright rejected, in my humble submission.
Lord,
Yes, sir.
reply for 2 minutes, my lord.
You can take more than 2 minutes.
Two things are admitted, my lord. One, I'm in possession. Next, he says that they don't want to dispossess me. I am nobody so far as the corporation is concerned. Then my learned friend also says that it was under the government. Now, when the corporation has taken it over, Lord, can my learned friend's clients show on record that they have given us notice that you are now under me and not the government? That has not been done. So I do not know what passes from where to where.
Where is your license, sir? Where is your license to trade in cattle?
Well, since my lord, 2011, when this notice was served upon us, since then, corporation is not issuing any license.
Not issuing any license?
No, but I have a shop there still.
How you are running it?
My lord,
How are you running it? Why you have not challenged it? Why you have not come to the court? So this is admitted by you that since 2011 you have been illegally running this.
No, I'm not
cattle.
illegally running.
Then
Domestic milk producer.
I'm in possession of the, I'm a
you are in
domestic,
possession of the land,
no, of the
Possession of-
structure also.
possession of the land and structure
And
is a civil
structure.
dispute.
Lord-
sir. You are
Lord, when
here
I'm a
before
cattle trader-
me.
Lordship will kindly bear with me for a minute, Lord.
Okay, sure, sure.
My learned friend says open ground. When I'm a cattle trader, the cattle has to be put on the undershed and an open ground only. It cannot be inside a room. And
I'm
cattle,
not disputing that.
Ah.
Sir. I'm only asking where is your license to trade?
No need, not read it out.
Where is your license? You have not put anything on record. So let's talk about the record, which is here. You have filed a writ petition, sir. From the writ petition, please show me that you are in possession. This is the property from where you are carrying on the trade. Where is your license to
Lord,
trade?
I believe, Lord, inadvertently, my Lord, it has not been placed, but I can give it on the supplementary affidavit. It's not that I
You
am
have to place it.
sans any license, my Lord, it's not that.
You have to place
Lordship.
something on record,
My
sir.
Lord,
Today, your
Justice-
writ petition.
If your Lordship
there is-
very kindly comes to page 29, Justice Talukdar's order, my Lord.
Sir, I've seen that order. Yes, please read it out. Yes, sir.
We
Read
are
out.
traders.
Yes,
It has
sir.
been, this has not been challenged by corporation in any forum, Lord, in the appeal court or anywhere, Lord.
Sir,
Accepted that we are traders,
I am not disputing that.
Lordship.
I am disputing your bona fide of filing this petition where you have not put anything on record to show that you have a trade license, you have a license to sell, purchase cattle. You don't have anything on record. Nothing has been put.
Then
on
Lordship will give me a time, Lord, I shall file my supplementary affidavit. I have those documents. I do have.
File
Lord,
your
in the meantime,
supplementary-
Lordship will protect me, my Lord.
I'm not going to protect you at all, sir. You have not put either I'll dismiss it and you file whatever you have to file, or you take time for your supplementary affidavit and file it.
In the meantime, my Lord, if they,
Meantime, nothing.
in the meantime, if they come and demolish everything, my Lord,
Let
then I
them
have,
demolish, claim damages. If you are a rightful owner, claim damages.
Lord, till such time, your Lordship hears my supplementary,
No,
Lord, Lordship will ask
Nothing,
them
sir.
to stay their hands, my
Sir,
Lord.
nothing.
Lord,
Absolutely
after all,
nothing.
corporation
It
is
will
in,
come to the court at least. with
after all,
some
corporation is in,
semblance.
after all, corporation is the owner,
Sir, some
landowner, my Lord.
semblance of relief can only be given if
Lord,
there
and,
is some
and then they will come with the bulldozer, even if I'm a squatter, my Lord.
Let
I
them-
ask myself this question, Lord.
Sir, let
Even if
them
I'm a squatter, my Lord,
show
or an illegal occupant.
Sir, today your case is entirely different. You file your supplementary affidavit if you want to. Otherwise,
Lord, Justice Gawai's judgment and directions on use of
take it
bulldozers.
to Supreme Court, sir. Please do not show me this. You
This-
take it to Supreme Court. Let me then pass an order.
No, my Lord. I'm just referring to it, Lord.
Yes.
I'm just referring to it. Lordship will give me opportunity to file my supplementary affidavit. My Lord, till such time, my Lord, if
Till
no
such
order
time,
is recorded, my Lord, let them at least desist from
No, sir.
causing any damage there, my Lord, dispossessing me.
Not
Lord,
no.
after I'm dispossessed, I'll come back to your Lordship.
Sir, you can claim your damages. We'll put them to
My
task.
writ petition will become infructuous, my Lord.
Nothing is here to actually grant you any relief, sir.
Lordship, I have the document. It is an
Nothing is there,
admitted
sir. Where
possession.
is the document? They are disputing it, sir.
They are disputing my
They are
possession, my Lord.
disputing everything that you are not even a trader.
No,
They
I
are
am
disputing, sir.
that is admitted in a judgment of the
That is
this
your
honorable
admitted
court.
on page, what he has read out also you
The
see that.
judgment of this honorable court, it is admitted, my Lord. That has never been challenged by the corporation.
Sir, you are one of the persons who has come. The writ petition
Lord,
was
if others
filed.
do not, Lord,
Writ
that's-
petition is not filed by you, sir. Writ petition of 2012 was not filed by you.
No,
You are
I
not
was
the
a party.
petitioner.
I was one of the parties.
You must be one of the parties. But it is not filed
Then,
by
Lord, if he
you,
does
sir.
not come
That
back, my Lord, that does not.
anyway, sir.
stop me from
Today, I can't grant you any ad interim protection till the time you don't.
Lordship will read the cost title. It's Sirajuddin and others. I was
I'm seeing it.
amongst the others.
I'm sure you might be among the others, sir. But that also doesn't give you right to do something which is not legally permissible. You show your right, I will grant you protection.
Lordship,
You show your right to trade in cattle with a license, I'll grant you protection.
kindly keep it tomorrow, my Lord.
You file your supplementary affidavit, we'll have it.
They admit it.
Lord, it is an admitted position that I'm a trader.
Sir, please.
It's a judicial pronouncement that I'm a trader, which is
Sir.
not challenged anywhere.
Please file your documents on record.
Lordship will keep it tomorrow, my lord.
All right. Mr. Carr?
Lord, I have nothing to say because Lord, if your lordship, Lord, this is a petition, your lordship can call for an affidavit if your lordship so wants, but I say that it deserves dismissal, Lord. Because
Affidavit, we'll see. First, let them establish their right. Then we'll see the affidavit. Learned counsel for the petitioner seeks and is granted liberty to file a supplementary affidavit to espouse their right to trade from the said site. From the site. Which site is this from? Which site? What is the location?
location to
Orphanganj cattle market.
From Orphanganj.
there is no cattle market, Lord, in that Orphanganj market. There is no cattle market.
What is the site? You must be having your license would be given for a particular site.
It is a part of Orphanganj market. This vacant
Just to place on record
Orphanganj.
the license granted by the municipality to carry on cattle trade. Learned counsel for the petitioner seeks liberty to file supplementary affidavit to place on record his license to carry cattle trade.
Lord, KMC has not issued any license to me because they have not even informed me that they have taken over the market. The DM has issued the license. I'll come with the DM license.
Whatever license you have, you come.
The DM license, my lord.
The areas, anyway, we'll see that tomorrow.
Tomorrow. Lord, Lord, no interim order need be passed, Lord. Let them do an undertaking that
I'm not making any comments.
any prejudice.
We'll see it tomorrow, sir.
My lord is keeping it for tomorrow.
Tomorrow? Tomorrow, sir.
Tomorrow or day after. Day after is normally your lordship's original side day.
This original side?
Yes. No, appellate side. Oh, sorry. Appellate side. Sorry. This is appellate side.
I'll come back with that.
Then tomorrow morning, Lord, could it be? Because tomorrow afternoon I am in little difficulty.
I'll keep it in top 10 matters.
Then day after tomorrow it might.
No. My learned friend has some problem for tomorrow. You can put it after.
The day after.
Day
Mr. Kaur have the problem.
Day after is the original site.
Original.
That's it.
Then it can go to Friday. It's okay. You have the problem. Keep it for tomorrow. Let's see.
Top 10 matters, Mr. Carr. We'll finish it off.
Yes, absolutely. It will take not more.
I am for the state, my lord. I am for the state, my lord. Last occasion, my lord, I was present, my lord, but my name has not been recorded.
Item number. Item number 19, I am appearing on behalf of the petitioner, my lord. In the last occasion, there was a direction for filing of exception, lordship, to the reply to the Bonga municipality. My lord, my exception was ready, but it was not affirmed because the petitioner is suffering from illness, lordship. I have that medical document, so that is why I am seeking at least 2-week adjournment.
There must be a stay, madam.
Yes,
Is there a stay?
No, there is no stay, lordship. Earlier, it was a stay, but it was vacated in the month of February.
File it by next week. Why do you need 2 weeks?
Well, since the petitioner has recommended for rest for 10 days.
Get a signature done. He doesn't have to do anything. Get a signature done from the petitioner.
Well, he has to affirm before the commission. Has to come.
All these, why this excuse? What is there in this matter? Yes, what is there in the matter?
But that it is that matter that in spite of receiving the application for approval of the plan, but 208 Lordship. There is a deemed approval, Lordship.
The 208 approval.
Yes, Lordship. 208, my lord. In the earlier occasion, it was affected from the order that there was a application for approval of the sanction plan, Lordship. But in spite of that, it was not sanctioned.
She's seeking 2 weeks time.
My lord, it is the same matter with what your lordship on last week has, my lord, disposed of. Same thing. They have not given us any.
Not the same thing, my lord. There is a little.
We have
bit,
already in our affidavit in opposition, my lord. Kindly see once.
Yes.
We have annexed the same document. Annex J.
You are just seeking time, madam. This is just an excuse.
No, my lord.
And it reflects poorly on you also.
I have the medical documents.
And my lord, the person.
We all know how medical documents are created, madam. Please.
Really, he is suffering.
We all know. This is the same matter. You are just trying to buy time and nothing.
No,
and even the persons.
And it reflects poorly as an officer of the court, madam. It reflects poorly on you also. Let me be very candid.
My lord, the previous matter, my lord, the petitioner's name was Shumir Kumar Das. And if your lordship kindly come to page 24, your lordship will find there is one agreement for promoting. He is a promoter in this matter, the first person, Shumir Kumar Das. He has the agreement with the present petitioner to develop that project. And it is just opposite the same lane.
My lord, not that, my lord, let me submit the one thing, my lord, that is in my case, it is not very much similar to the earlier case.
It is
because I have documents wherefrom I can satisfy your lordship that it is not the same case, lordship. It is not the same case.
What is your name?
My name is Shravani Sarkar.
We'll give her time.
So,
1 week time only suffice, lordship.
Learned counsel for the petitioner seeks and is granted 1 week time. Further 1 week time to file her exception to the report. Let this matter be listed on. No. 28th July.
20th July.
Earlier, my lord, my lord, I have. My name has not been recorded, my lord. I am for the state, my lord. Earlier occasion.
Now it will be recorded, sir.
Yes, my lord. Earlier date, my lord.
Not on the earlier one. Now it will be recorded. Just record his name.
My learned senior, my lord, name says.
Sorry?
My lord, my learned senior names has been recorded, my lord. Kindly.
Learned senior's name has been recorded.
Earlier occasion, my lord. And my name has not been recorded, my lord.
It's all right. Now it will be recorded.
First, the petitioners are the deities, Hindu deities. They own a water tank, huge water tank, man. And that is a devoted state. And actually, what happens? Municipal authorities, under the guise of an act, West Bengal Inland Fisheries Act, took possession of the property as if it is a fishery. What I should place before lordship, before going to some other ends, the definition of fishery given in the act itself. My main attack is this one. They have no jurisdiction. They have no jurisdiction to occupy this property under the West Bengal Inland Fisheries. May I hand over your lordship the act, the Xerox copies, of course.
Give it.
Also. But she can comes to
yes.
They have invoked paragraph section 17A, capital A. Before that, lordship kindly come, it takes the the objection is very clear, small one. An act to provide for the conservation, development, propagation, protection, exploitation, disposal of inland fish and fisheries in West Bengal and for matters connected therewith. Next is, whereas it is expedient to provide for the conservation, development, almost same thing, propagation, protection, exploitation and disposal of inland fish and fisheries in West Bengal for matters connected therewith or incidental thereto. My contention is this, this is a devotor of property. It's a simplicity tank. I shall also rely on now section 17 they have invoked. Section 17 also speaks about all this 17A fisheries. It cannot go out. This is the object of the object of that. Lordship. And one thing is Lordship kindly takes from it. What is the condition of the tank? Lordship kindly comes to page the petition itself. If I may take you, Lordship, page 43, annexure P1. It's a document coming from the municipal authorities themselves, not their position. Next. Number 3, Lordship, inspection report. They are enclosing the inspection report, and Lordship kindly sees for the very next Lordship turns over, it's at 44. Lordship sees on the left-hand column it is tank. What is the caption of the document? The Calcutta Municipal Corporation Municipal Assessment Book, lands for building assessment department. These are the things going on. These are the this has been described as land. Land simpliciter. Tank simpliciter. It is not and cannot be a fishery. Same thing, Manas, your Lordship kindly sees the premises number is given. Inspection report. What is timing? Page 45. 45. It's at page 45, Manas. It's a tank. On the left-hand column, 87E, that's the premises concern. 87E is the tank. Tank simply, they are describing, taking it to be a fishery and has taken possession of it. No, this is without jurisdiction. We moved a writ petition before this honorable court, and on that, Mr. Justice Sinha, directed us to file a representation before the authorities, Municipal Commissioner. He said he is the competent authority under the Act itself appointed. And actually, what happened? The petitioners preferred an appeal therefrom that the order directing filing of representation, and on the representation, an appeal was filed. An appeal came up before. Your Lordship was also a party to that. Your Lordship also almost followed that order, asking my clients to go file a representation. And the representation was filed. Lordship kindly sees what is happening. We filed a representation. It's at page 50. Lordship kindly 60.
ये जो उसमें फाइल मैडम
in our representation before the Municipal Commissioner, who is the competent authority, who has been directed to consider our representation. At page 60 page 60 is the representation starts. Now, in course of hearing, it transpired that some points have been left out. We sought leave of the Municipal Commissioner, and Municipal Commissioner gave us leave to file additional representation. And that additional representation was filed. Lordship kindly comes in. I will not take your Lordship's much time, because all on jurisdiction, lack of jurisdiction. because this is not a fishery, it has never been used as a fishery or pisciculture. Logically comes to page, the manner in which it was disposed of logically is logically gives the meaning. I mean, order. Yeah. Yes. No, 95, just a minute. Yes. No, yeah. The order has to actually, one order has been used, which is has been impugning this writ proceeding also. It's at page 91. It's 5th of September 2024. Now, Lordship kindly comes straight away to the letter portion. I need not trouble your Lordship. Other things, there are very many things that to be submitted. But order, kindly Lordship sees page 94. It is that the matter was heard partly and was adjourned with a direction. This is very important. Be given to the petitioners by allowing the prayer of the petitioner to submit an additional representation, what you are just submitting, in continuation of the representation dated the first one, 14th August 2024. On receipt of the same, the department concerned will put up the same before undersigned for final order. Then comes the final order. She is surprisingly shortcut করে দিল। Final order is a page, the very next page. Lord kindly sees. I'm skipping over for the entire thing. The relevant portion, I'm just. Lord kindly gives the meaning. Just show you the Lordship the relevant portion. Right. Yes, Lord kindly text page 77, 97. Art submission made by the petitioners and the observations of the department, it is clear. I mean, my response submission would be none appeared on behalf of the department. No affidavit was filed, although those have been referred to in this representation. I've thrown specific challenge on this. It is clear that there is no contempt on the part of the department and the tank under the control and management of the water body being taken up by the competent authority for promoting pisciculture, which is highlighted in their affidavit. No affidavit served, no affidavit filed to our knowledge. And to prevent the environmental degradation by cleaning the said water body situated at questioned premises as per notice for taking over the water body management and control for a period of 25 years commencing from the issuance of notice in the year 2003. As soon as the said period is completed, the said water body be handed over to the owners claimants after the expiry of management control period with the undertaking, and will keep this said water body always in clean and that the environmental degradation does not occur. This we are also disputing. He had no jurisdiction at all to decide this. He has gone into this also, and there is no environmental degradation, no notice, nothing of the sort has been given to us. Apart from the logical takes the chance over. We were to be given hearing. Yes, logically said, comes up by page 96 itself. The paragraph starting with nevertheless, since an issue has your lordship got it? Nevertheless, on the left hand side, it is 96. Nevertheless, since an issue has been raised with regard to the jurisdiction of the competent authority and the applicability of the act in question accordingly, leave is granted the petition to file fresh representation highlighting their grievances. That is why we file. In this regard, such a representation is made along with the supporting documents. We file the representation. The same shall be considered by the Commissioner of Calcutta. A reasoned order shall be passed by the Commissioner. Yes. Apart from that, you also can consider. Jump Now, what happened, Manoj, if I make again harp on this document, this is 3rd of October 2024. Starts at page 95. Page 95, P10. Now, this Lordship says he passes the final order without considering my additional representation. He gives time, adjourn the matter, fix it, set final order. Now he passes the final without hearing me. This is gross negligence and abuse of the power. Apart from that, upon logically comes to yes. Logically comes to page 47. It's a notice asking us to show cause that the proposal of DG such and such a management of Kasipur, most of I'm skipping over, that the proposal of the department, second paragraph, department for engagement of the above no, for the proposal 47, that the proposal of the department for engagement of the above mentioned Kashmir Census Committee Gosti. Yes, this is important. For pisciculture at the water body at 87E, this is the premises, water body 87E Kashmir Road for 3 years at an annual rent of rupees 10,000 per year. That is annual rent. This is about 5 bighas area. I mean, 10,000 per year means 800 something per month. Exorbitant. How is disproportionate?
That's also after deducting the certain amount.
And this should be again. Now they are what they are deducting some. In the next paragraph, Woman 3, that the proposal of the department for payment of rent at the rate of 7,274. How they have come? Be such only per annum after adjustment of service charge amounting to 270.
Sir, you're not challenging the assessment.
Yes.
You're challenging the assessment also.
Yes, we have.
Sir, here in the writ petition, what are you challenging?
I'm challenging the locus standi, the jurisdiction of the authority, municipal authority, to take this position, and the fixation of rent also. Wholly disproportionate.
Where is that, sir? Where is that? In your prayer clause, where is that?
No, what I'm yes, sir. I follow what you are following from here. That we are taking grounds, specific grounds at there. We can formulate the.
Go to the municipal tribunal, sir, and challenge the taxation.
Beg your pardon?
Go to the municipal tribunal and challenge the taxation. Today you have filed the writ petition only stating that they don't have a power under 17A to take your tank, and the orders passed by the municipal commissioner is under challenge. The 2 orders passed by the municipal commissioner is under challenge. These are the 2 things which you have challenged.
Yes, sir.
And nothing more, sir.
No, I'm saying the 17A does not apply at all. They are exercising their power under section 17A, fixing the rate at 10,000, that's 800 something per month. Everything comes in. And I'm taking the specific grounds also. This is wholly non-application of mine, and it cannot be only 800 rupees per month. I've taken up specific grounds of there.
Anything more?
Huh? Yeah? He বলছে give me. Yes.
Anything more, sir?
Not see. See. See na Yeah, logically comes to page 38 once. A writ of writs in the nature of mandamus and order assessing, disclosing the amount of lease rentals of rupees 10, and since 400, they have let out the premises of the entire tank. They have leased out, they are enjoying the usufructs, and nothing else is paid. They are paying only poultry sum of rupees 800 and odd. All these actions are without jurisdiction.
All right, thank you.
No, can you give me? And then that apart, huh? Tax. And yes, here logically takes the tax bill. In the meantime, we are fighting the appeal. It's at page 98. They have raised the tax bill, property tax bill. It's about 54 lakhs. Offering 10,000 yearly and asking for 54 lakhs for 2 months. Yeah, quarterly comes about 20,000 odd. This is really confiscation. I shall be relying on a judgment, my lord. What you can see is now what is there? The income they are really confiscating my property in the way. What you can give a minute. 61 is Yes. I'm relying on AIR 1961 Supreme Court say this is really confiscation of the property. Confiscation. Not you can AIR 1961 Supreme Court, page 552. Not you can come straight to paragraph.
Sir, you have to give me a copy.
Yes, yes.
Or a printout.
Yes, definitely. I'm coming. Paragraph 8, logically says. Well done. And press paragraph 8, then paragraph. Here it was a Mupil's case, famous case, and it was struck down because it was held. That is full of confiscated. This is fully confiscated. It is, may I read out paragraph 8. It is common ground that the tax, assuming that the act is really a taxing state, a taxing. Taxing state and not a confiscatory measure, as contended on behalf of the petitioners, has no reference to income, either actual or potential, from the property sought to be taxed. Hence, it may be rightly remanded that the act obliges every person. May I take the help of my junior?
I'll be placing part of paragraph 8, Your Lordship.
Ordinary.
Ordinarily, a tax on land or land revenue is assessed on the actual or the potential productivity of the land sought to be taxed. In other words, the tax has reference to the income actually made or which could have been made with due diligence and therefore is levied with due regard to the incidence of the taxation. Under the Act in question, we shall take a hypothetical case of a number of persons owning and possessing the same area of land. My lord, this portion, what would be evident, my lord, from the record, your lordship, the amount that the corporation assessed to pay to me, that is 10,000 per year, that even after deducting 2,000 and odd rupees, to well, that comes to something around 7,000 and odd rupees yearly. And on the contrary, your lordship, they're assessing towards taxes, your lordship, as has been placed, my lord, as the last section at page. I'll be placing the subsequent line also, your lordship. Hypothetical case of a number of persons owning and possessing the same area of land. One makes nothing out of the land because it is arid desert. The second one does not make any income, but could raise some crop after a disproportionately large investment of labor and capital. A third one is in due course of husbandry is making the land yield just enough to pay for the incidental expenses and labor charges besides land tax or revenue. The fourth is making large profits because the land is very fertile and capable of yielding good crops. Under the Act, it is manifest that the fourth category in our illustrations would easily be able to bear the burden of the tax. The third one may be able to bear the tax. The first and the second one will have to pay from their own pockets. If they could afford the tax, if they cannot afford the tax, the property is liable to be sold in due process of law for realizations of the public demand. It is clear, therefore, that inequality is writ large on the Act and is inherent on the very provisions of the taxation section. It is also clear that there is no attempt at classifications of the provisions of the Act. Hence, no more need be said as to what could have been the basis for a valid classification. It is one of those cases where the lack of classification creates inequality. It is therefore clearly hit by the prohibitions to deny equality before the law contained in Article 14 of the Constitution. Furthermore, Section 7 of the Act quoted above, particularly the latter part, which vests the government with the power wholly. My lord, then, my lord, skipping over, my lord, to
paragraph 10. 10 has been type
my lord, paragraph 10. It's a type 1, your lordship. That the provisions aforesaid of the impugned Act are in their effect confiscatory is clear on their face. Taking the extreme case, the facts of which we have stated in the early part of the judgment, it can be illustrated that the provisions of the Act, without proposing to acquire the privately owned forest in the state of Kerala, after satisfying the conditions laid down in Article 31 of the Constitutions, have the effect of eliminating the private owners through the machinery of the Act. The petitioner in Petition 42 of 1958 has been assumed to own 25,000 acres of forest land. The liability under the Act would thus amount to rupees 50,000 a year, as already demanded from the petitioner on the basis of the provisional assessment under the provisions of Section 5A. The petitioner is making an income of rupees 3,100 per year out of the forest. Beside the liability of rupees 50,000 as aforesaid, the petitioner has to pay a levy of rupees on the surveyed portions of the said forest. Hence, his liability for taxation in respect of his forest land amount to rupees 54,000, whereas the annual income for the time being is only 3,100 without making any deductions for expenses of management. Unless the petitioner is very enamored of the property and of the right to hold it, may be assumed that he will not be in position to pay the deficit of about 51,000 every year in respect of the forest in his possession. The legal consequences of his making a default in the payment of the aforesaid sum of money will be that the money will be realized by the coercive possession process of law. One can easily imagine that the property may be sold at auction and may not fetch even the amount for the realizations of which it may be proposed to be sold at public auction. In the absence of a bidder forthcoming to bid for the offset money amount, the state ordinarily becomes the auction purchaser for the realizations of the outstanding taxes. It is clear, therefore, that apart from being discriminatory and imposing unreasonable restrictions on holding property, the act is clearly confiscatory in character and effect. It is not even necessary to tear the veil, as was suggested in the course of the argument, to arrive at the conclusions that the act has that unconstitutional effect. For this reason, as also for the reason for which the provisions of sections 4 and 7 have been declared to be unconstitutional in view of the provisions of Article 14 of the Constitutions of India. But what we are to place it before your lordship, that a plot of land upon which measuring about more than 4.5 bighas of land, my lord, they forcefully take it without there is no provisions of law under which they had confiscated the land, the management of the pond, and they assess the rent to be at rupees 10,000 for a whole year. After deducting, it comes to 7,000 and odd. And on the contrary, they are putting the putting the taxations of the property at an exorbitant rate. And just
challenge that assessment before the municipal tax tribunal.
My lord, this is
you have not challenged it here. You have challenged what is under challenge here is 17A, that they don't have the power to take.
That is yeah. Yes, Lord. My lord, kindly take to paragraph prayer E of my prayer, your lordship. Kindly. Are it in the nature of mandamus and orders?
Alternate remedy available in law. You exercise that.
That is there, your lordship, but this is highly, my lord, this is grossly illegal, your lordship.
You can take that over there.
That is your lordship. That is definitely. That is we have the options to move before the tribunal.
Yes.
But this, my lord, the entire actions of the corporation is illegal, and the face of it, your lordship, right from the beginning, invoking section 17A, taking management of the pond.
You are also sleeping for a very long time. Yes. Done. Anything more?
That is, my lord, I can't make anything. It is all before your lordship.
Yes, that's what I'm saying. Any more submission? You have made your submission. Anything else?
My lord, that is only two.
Yes. Yes, Mr.
As I know, my lord, on the issue of tax issue, my lord, they moved an earlier petition that was ended with giving a liberty to him to approach before the municipal assessment tribunal. My lord, that, my lord, that I know, because he initiated a contempt proceeding that was not accepted by the court. That is my lord, they are in earlier proceeding as I remember. So far as
they have not put anything on record.
This case is a different one. Your lordship has rightly pointed out that this case, my lord, that admittedly the position of the tank was taken over, management and control was taken over in 2003. And
how could they do it?
Did he say anything?
Sorry, your lordship.
Well, whenever such an action is taken, then my lord, the notices are issued and thereafter it is taken over. Well, they are in occupation of the property. They know, my lord, that it has been taken over way back in 2003. They came to this court alleging in 2021, after 18 years, that, my lord, that it cannot be taken over. And we have not been given a hearing. That was precisely the issue in the earlier proceedings. Then the court said, all right, since he has not, he is alleging that he has not been given a hearing and only one issue he has taken, that is a simplicity tank and not Devottar tank. Therefore, simplicity tank If it is not a Devotta tank, then it cannot be taken over. That is their issue. Now, my lord, that was directed by the division bench, directed that he represented to be considered by us. Then now, by the way, the 25 years of management control under the act itself, the 25 years it can be taken over. It even kept with us, management and control. Now it will be returned back to the owner of the property, and he has to maintain as my lord was being maintained by the authorities. In that way, environmental degradation, physical, whatever it may be, they have to maintain that. Since they did not maintain it, that is the reason, my lord, it was taken over. Now, after, my lord, 18 years, they have, my lord, come to this court, and court directed, we have considered, this is the issue. If my learned friend has taken, considered, my lord, any issue, that with only that was simplicity or Devotta, it cannot be taken over. But there is a, there is a provision for appeal under section 19. If that is considered that it has been passed after giving a hearing under the court's order, the 17A, then he has to prevent an appeal, because the law says that environmental degradation and also a land manner which is capable of maintaining or using it for the pisciculture. That is the order has been passed. Therefore, either he could wait for, my lord, few more years, because it is all the way, my lord, going to end, my lord, 25 years. Number one. Number two, my lord, he can apply, my lord, he can prefer an appeal. Instead of coming here, he could have preferred an appeal before the Deputy Director of Fisheries under the Act itself. Section 19 is applicable here. Because he is complaining about the action under Section 17A.
No jurisdiction. Section 18.
18, I'm sorry. Therefore, even if it is contention that it is not well applicable, then appellate authority could say it is wrong, it is returned back. We have, my lord, already is about to return it back, but after 2-3 years.
Nobody will entertain this. This is
my lord,
too long. But file a report. We'll see.
My lord.
But as far as the tax is concerned, they are saying they have not challenged it.
We have.
Here. The petition to file.
He's saying you have challenged it in a separate writ petition.
আগে ফাইল করেছেন petition?
No.
কি?
No.
আমি দেখাবো।
Anyway, sir, this is not maintainable. You better challenge it somewhere else. I'll issue notice on everything. But
May I submit one of this? The management has finished. Just that. Section 18 appeal alternative remedy, Lordship, they are saying, does not lie. I tell you, Lordship, why. It is without jurisdiction, inherent lack of jurisdiction.
I'm not impressed by his argument, so you don't have to argue on that.
I will be relying on a judgment, my lord.
So you don't have to argue that point. I'm asking them to file their report.
As you wish.
Take down. The petitioner has preferred the present writ petition challenging the order dated 5/9/2024 and 3/10/2024 passed by the municipal commissioner, whereby the petitioner's representations concerning the Battar tank situated at premises number 87E, Kosipur Road, Calcutta, were rejected. Full stop. It is the case of the petitioner that the water body in question is the Battar property belonging to the petitioner and is used exclusively for religious and temple related activities. In the year 2003, a notice was issued under the provisions of West Bengal Inland Fisheries Act 1984. 1984, right?
Yes, sir.
1984 by the competent authority informing the owners that the water body was not being properly maintained and required restoration, including the initiation of pisciculture activities. Full stop. In the absence of any response, in the absence of any response or objection, in the absence of any response or objection from the owners, the competent authority passed an order taking over the management and control of the said water body. Full stop. Nearly after 17 years later, the said order was challenged by the petitioner by filing WPA number 9696 of 2021. Before the learned single judge. Full stop. The writ petition was disposed of by order dated 25/7/2022, whereby the matter was remanded to the respondent authority for reconsideration of petitioner's representation. Full stop. The order of the learned single judge was carried in appeal in MET number 2040 of 2022. Full stop. The Honorable Division Bench, by order dated 2/8/2024, dismissed the appeal and affirmed the judgment of the learned single judge. Full stop. In compliance of the said order dated 2/8/2024, the respondent considered the matter and considered the representations and issued the impugn orders, holding that the water body would be handed over to the petitioner after expiry of the current management control period of 25 years. This is what it is?
Yes.
25 years, subject to an undertaking that they will maintain the water body in a clean and environmentally compliant manner. Full stop. Being aggrieved by the said orders, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 10 weeks.
4 weeks.
My lord, the one thing I will submit before lordship, that since the taking over the management, nothing has been paid to us. Nothing.
That you
Not a
were
single
also,
passive, your
you
lordship.
were also sleeping for a very long time.
My lord, your lordship knows the situation. To fight against the establishment, your lordship, is very tough.
It doesn't take 17 years to wake up.
It is there, your lordship. It is there. Still, my lord, if this would have been against a private party, it would have been otherwise.
Not at all.
Yes.
You have also forgotten your right.
No, it's not forgotten, your lordship. It's
Then,
not that.
when did you took up this case?
I'm with Mr.
When did you get involved in this matter?
2021.
Then? And before that?
Some debacles, manner. The managing trustee was there, he died.
Whatever it is, sir, you have also slept over your rights.
And if it is without jurisdiction, we can not telling.
Obliged, your lordship.
And the best is, wait for 25 years, you will get it back. It will take, how much time is left now? 2003, they have taken 25 years. How much time is left?
5-6 years.
Not even 5-6 years, sir.
Not in 5-6 years.
Not even 5-6 years. Mr. Ghosh will tell us.
2, 3 years.
How much time is left, Mr. Ghosh?
Years already passed.
Past 3 years.
Matter of 2.5, 3 years.
2.5 years. And had it been said at the time of issuance of the notice, they will maintain it properly, there could be no occasion to take over the management.
আপনি 2.5 বছর পর পেয়ে যাবেন সুজিত দা, ছেড়ে দিন।
Give it back to him.
Then we take back the papers.
Second. Obliged to lodge.
For the petition. Lastly, it was heard, my lord, on 19th December, my lord. The municipal authorities were supposed to file a report. I am the tenant, my lord. Without hearing me, the demolition order has been passed, my lord, which I have challenged. And I am admittedly a tenant, my lord, and demolition order was passed, my lord, on 11th December 2024. On 15th, the respondent authorities have came. I have asked for the copy. They did not give, my lord. From the police station, I have got one photocopy which I have annexed, my lord. That is under charge, my lord. My point is, my lord, no opportunity of hearing, my lord, has been given to me, my lord. And the KMC is supposed to file a report, whether I was present or not.
Who said TMC has to file a report?
No, my lord. The last occasion, my lord, on 19th December, my lord, kindly see the order of 19th December of this.
Relevant records. Where is the direction to pass
my lord.
pass any order affidavit? Or
No, my lord. The corporation shall produce the. They have said they will come with the records, and they have submitted that they will intimate not to take any step regarding that demolition. My lord, that is written, my lord.
what all documents you have put on record?
My lord, I am an admitted tenant, my lord. I am not the land.
What are the documents for tenancy you have put on record?
My lord, at that time it was, I did not have the time. It was leave matter, my lord.
Sir.
My lord, I understand. My lord, kindly give on the time, my lord. I shall file the rent receipts and the photographs of the said building.
Why have you filed this writ petition with what? Nothing. Dismissed.
No, ma'am.
The present writ petition is dismissed, bereft of any material particulars.
Kindly
The petitioner states that he is a tenant. No document is placed on record.
Kindly,
full stop. The petitioner had not appeared in this matter on last 2 occasions. Full stop. Today, the petitioner has entered his appearance and seeks time to file supplementary affidavit. Full stop.
Kindly consider. It was a leave matter. I could not file that time. It was very urgent. That is, I have filed.
You will file any petition urgent.
That the next day the demolition will be.
Either you seek liberty and withdraw this petition.
My lord. Liberty may be given.
Learned counsel for the petitioner seeks to withdraw the present writ petition with liberty to file proceedings in accordance with law. Full stop. Anything you'll file in.
That was urgent, my lord.
And then you don't appear also in the matter.
No, my lord, last occasion.
2 occasions.
22, my lord, I am withdrawing it, my lord.
But I am for the state in this matter.
Mr. Shondipan Banerjee is appearing on behalf of Haram Municipal.
I'm withdrawing it, my lord. There are defect.
Withdrawing it?
Yes, my lord.
You file these petitions for what? Illegal construction is demolished?
Yes, my lord. But in written representation, there is a defect that the landlord has not made the party and person complained of.
What is the status of the unauthorized construction? Who's appearing?
These things are going on in house.
This is the reason why I will not allow him to
who has submitted is a habitual objector. My lord may seize his address.
and the address of the construction, and I can bring many other briefs where he has made this submission and filed writ petitions. Immediately when they are hand and gloves, they immediately say, come and say that I want to withdraw.
Santosh Pathak.
Santosh Pathak.
All right.
All right. Yesterday also, I have not pointed out.
File a affidavit.
Yes.
How many petitions you have filed in this
Yes,
court?
yes.
Where you have challenged
These
unauthorized.
things have to be done, my lord. Otherwise, we will face difficulties.
No, I'll send him
Promoters
to,
are very-
I'll send him to jail. You wait.
Promoters are very dangerous, that I know.
And you are the lawyer in all the matters?
No, my lord, it is a transfer. It is a transfer. The first time today I filed the work.
Very good.
I do not know about it, my lord. I will ask.
File your affidavit. Mr. Pathak will file his affidavit, putting on record how many writ petitions he have filed
Yes, grateful.
in West Bengal challenging unauthorized construction.
Even I will search also, my lord. Even
You forget your search.
Yesterday, one writ petition was there. Mr. Owen Banerjee was appearing.
Somebody has to go to jail. This will not stop.
This will. Well,
Learned counsel,
may be
learned
granted to us
counsel
to
for the
proceed
petitioner
with the demolition.
speaks to withdraw the present writ petition. Full stop. This court observes that the petitioner is in the habit of filing writ petitions alleging unauthorized constructions
In multi-storied buildings.
in multi-storied buildings all around West Bengal.
বউ দুটো ফ্ল্যাট নিয়েছে
Full stop.
বউ দুটো ফ্ল্যাট নিয়েছে এই বিল্ডিং এ
His wife has been given 2 flats in this building.
His wife has taken 2 flats.
2 flats in this building, my lord.
2 flats.
I'm sorry to say, I should not say these things.
No, you should. This is very important to put an end to this. At least somebody should.
And I am doing this type of objection,
Learned-
giving this type of objection. For that reason, I am in a threat.
Learned counsel for the petitioner. The petitioner, sorry. The petitioner is directed to file an affidavit indicating the number of writ petitions which he has filed before this court
Exactly.
for illegal and unauthorized construction within the state of West Bengal. Full stop. The said affidavit shall be filed within a period of 1 week from today. Let this matter be listed on 29th July.
My lord, petitioner will file the affidavit, my lord.
Yes, the petitioner will file. Not you, sir. 30th July. 30th July.
My lord.
Learned counsel for the petitioner states that this is you are appearing for him for the first time. Have you appeared for the petitioner in any other matter?
No, my lord. For the first time, today I filed. It is a transfer brief. Today I have filed the wakalatnam. I am not aware of.
The earlier advocate denied.
Who's the earlier advocate?
Earliest Archis Mansingh, someone.
These things happen. Earlier advocate denied to withdraw. I'm sorry, I know these things are going on.
Tell your client, this is the last. Anything else you want in the affidavit, Mr. Banerjee?
They should details of the petitions, numbers, and also the orders.
Details of the petitions along with the copy of the writ petitions with orders passed in those writ petitions.
Right.
2 weeks time though. Take 2 weeks. List on 30th. 30th.
I am facing serious.
Be careful,
My
sir.
luck is not running well, my lord. In whatever matter I am appearing, there is a defect, my lord. My luck is very unfortunate. I have knowledge, I wouldn't have filed the wakalat today, my lord.
I am facing serious complaints, serious threats for this.
This is the all India phenomenon.
My lord,
It's not only confined to
I am very,
this high court.
I am very much seriously, in the wedding also, I could not appear in the Howrah and
Mr. Banerjee, we have sent people to jail.
I am grateful to your lordship. These things are happening.
This is extortion.
When I found that he is withdrawing, I immediately pointed out and mentioned before it.
You know, whenever somebody withdraws, even
And one thing, my lord, only one thing, liberty to continue for demolition.
there's no stay.
No, actually, what happens when these things are pending before the court?
No. You go ahead with the demolition. All right. Next. Again, none appears for the petition.
Again, no one appears in last date also not.
And for the statement.
There was no appearance. There was no appearance on behalf of the petitioner on 9/7/2025.
Demolition has taken place in this.
Full stop. Today also, there is no appearance on behalf of the petitioner. Full stop. It seems the petitioner is not interested in pursuing the present writ petition. Full stop. The same is dismissed for non-prosecution.
24. Other side they appear for enough.
Petitioner. আমার senior আছেন। My lord, I am for the petitioner. The advocate on record for the petitioner is ill. My lord, please kindly mark this matter as not this week.
Let this matter be listed before another bench, subject to orders of the Honorable Chief Justice. I was part of the division bench.
My lord, my lord.
This is done.
Oh,
There's a division bench order.
As your lord.
I am part of that.
My lord is releasing them.
Won't be right, Mr.
My lord.
If you see the order of
My lord, my lord.
20th of September, I'm in the division.
As your lordship.
Let this matter be listed before another bench since back in since I was part of the division bench, which might pass the order dated 20th September 2024. Let this matter be listed before, let this matter subject to the orders of the Chief Justice. Let this matter be listed before another bench, subject to the orders of the Honorable Chief Justice.
এটা বড় released.
27.
Item number 25, Your Lordship, for the petitioner. Your Lordship, I'm trying for not today.
Madam, you have made not today. Now I remember your face every day, not today. Why?
Your Lordship.
You argue it today.
Last time only I appeared on
Yes.
Thursday and prayed for not this
Not
week.
today.
Your Lordship, tomorrow positively my senior will be here. He's unable to come today, Your Lordship.
What is this not today business? You get prepared. Just take down proxy counsel, so and so proxy counsel, Rukhsar Praveen states that the main arguing counsel is indisposed. She prays for an adjournment. Let this matter be listed. When do you want?
Well, any day as per your lordship, convenient time.
Let this matter be listed on 30th.
30th.
Grateful, Your Lordship.
কাজটা কত দূর হয়েছে না না কমপ্লিট কত দূর সেটা জানতে হবে।
We can have it tomorrow also and finish it off.
Tomorrow matter is very short.
We can
তাহলে
have
আমি
it.
দুপুরে আমি অ্যাপ্লাই করছি, মেসেজ করে দাও।
You want tomorrow?
Yes.
All right, shall we make it not today?
Not today. As he prayed, not today.
Not today, we'll keep it tomorrow.
Yes.
Tomorrow. Not today, cut down the order. Not today, tomorrow. We'll finish it off.
They were supposed to add one party, the successful bidder. We do not know whether their party has been added or not, because we have not been served with any.
Without adding party, যদি আসে তাকে দেখো তার এগেইনস্টে কোনো অর্ডার দেবে কিনা দেখো।
But I appear for the petition, my lord.
Well, I'm not the statement.
But this is my affidavit of service. But the petitioner runs a business of food and beverages, my lord. Petitioner was initially running a business of biryani shop, my lord. Now he has closed down it, and my lord, the petitioner is running, have taken the my lord, the franchisee of Holdiram company, my lord. The grievance of the writ petitioner is that the private respondent, my lord, have unlawfully, my lord, the encroach upon the, my lord, the public footpath, my lord, and by operating and, my lord, the erecting, my lord, the unlawful, my lord, stalls with shade just in front, directly in front of the petitioner's shop room, my lord, causing serious prejudice to the ingress and egress petitioner's premises shop, my lord. My lord, which is in violation to section 371 and 372 of the Kolkata Municipal Corporation Act 1980, my lord. Section 371, my lord, prohibits, my lord, any unlawful stalls on the footpath, my lord, and 372, my lord, the casts duty upon the corporation to take steps against such, my lord, the unauthorized stalls, my lord. My lord, we, my lord, made a complaint before the municipality, my lord, page 33, my lord, on 19 December 2024, my lord. That has not been dealt with till date, my lord. And also, my lord, I have also annexed the photographs, my lord, page 22 and 23, my lord.
This Haldiram only led to a shooting of somebody, huh?
No.
In earlier.
But it is in, but that is Holdiram in, in North 24 Parganas, but
somewhere.
I appear for the corporation, my lord, led by Mr. Vimal Kumar Shah.
That is in.
My
lord, I am appearing. You have KMC, my lord. I beg to appear in virtual mode, my lord.
You are always appearing in virtual mode, Mr. Shahi. What is the problem?
My lord, my left side leg is blocked. That's why I am appearing.
Oh,
virtual
you
mode,
have
my
sprained
lord.
your leg? Fracture or what?
No, it's blocked, my lord.
Blocked?
My heart was blocked. Thereafter, my two legs was found blocked.
Oh. Your calf is the second heart. Yes, Mr. Shahi.
My lord, I have the instruction. My junior will submit before your lordship. My lord, though encroachment, that means private respondent who are sitting there totally unlawfully, my lord.
Inspection. Post all that in the canal. So you remove it, file a action taken report. Inspection has been done on 8th of January. We are sitting in July. Why you have not removed, Mr. Shahi?
My lord, please give me 8 weeks. We will remove the encroachments whole persons, my lord.
You consider his representation and finish it off.
Great.
My lord.
Where is the representation?
Page 33, my lord.
Whatever action you have to take it. Since January, they are taking action. Madam, the inspection is of January. Read the report. Take down the petitioner, comma, in the present writ petition, comma, is aggrieved by the inaction of the respondent authority in failing to remove illegal encroachment from the footpath in front of petitioner's shop, comma, situated at 136, comma, Karl Marx Sarani, comma, Calcutta, comma, allegedly at the instance of private respondents. Full stop. Learned counsel for the petitioner submits that they are running a franchise.
No, we are my petitioner running for a
Franchise of Haldiram.
Haldiram.
Are operating a franchise of Haldiram from the aforementioned premises. Full stop. The footpath in front of the shop has been encroached by the private respondents, comma, who have erected structures thereon. Full stop. The encroachment not only obstructs pedestrian movement but also adversely affects the business operation of the petitioner. Full stop. Despite having submitted representations, the respondents have failed to act upon the same. Full stop. Learned counsel for the respondent submits that they are ready and willing to decide petitioner's representation dated 19/12/2024. Full stop. In view of the said submission, learned counsel for the petitioner submits that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the submissions made by the counsel for the parties, this court directs the respondent number. Who will be the respondent number?
But the respondent 3, Municipal Commissioner, my lord.
The respondent, Calcutta Municipal Corporation, to decide petitioner's representation dated 19/12/2024 within a period of 8 weeks. Mr. Shahi, how much time?
My lord.
Within 1 to 2 weeks, my lord.
Within 6 weeks. Within 6 weeks from the date of communication of this order, comma, strictly in accordance with law, comma, after affording an opportunity of personal hearing to the petitioner as well as the private respondents or any other stakeholder, comma, by way of a speaking order, full stop. With the above direction, the present petition is disposed of. Affidavits have not been exchanged. Contents are not admitted.
Deeply obliged, my lord.
Lord, yesterday this matter was taken up when I have submitted.
Mr. Banerjee, if you have any details of that, Mr. Pathak, can you please give it to me?
I am also collecting that. I told my junior.
Just give it so that I incorporate in the order.
Yesterday a matter was.
That's what. Since you are aware, at least 1 or 2, if you can. One will
I have at least 2 to 3.
Just give it.
But he has filed many cases.
Just Manoj, just give it to him. By the end of the day. By tomorrow, just hand it over so that
tomorrow, day after tomorrow, I will give.
Give it tomorrow so that I can clear the order.
My lord, this matter when a division bench has already disposed it of. That was ordered by the coordinate bench. For that reason, they have not come, my lord.
None for the petitioner. The present petition is dismissed in default.
ওটা দিয়ে দিই? এই আজকেই হয়তো একটা দিয়ে যাবে।
Even if you give me one, that will,
One I will give today.
yes, that will suffice.
These things are happening. And
Every-
they are withdrawing.
Every
That's
day,
good. They have complained, but they are withdrawing. Learned advocate change themselves because learned advocate I think is good.
our court
Previous
should not,
learned
our court should not be used for this purpose. That's most important.
promoters are very bad. But at the same time, these persons are also to be treated.
Yes. Next, monthly list.
কোথায় যাচ্ছেন দাদা? 23 আমাদের।
72 আমাদের।
73 আমাদের।
I'm for the state lordship.
Lord, I am for the respondent 2, 3 and 4 municipality. Respondent number 2, 3 and 4, Uluberia municipality. My junior is there.
Yes, nobody for the petitioner. The problem is that.
Lord, they can be dismissed for default.
Not on the first go. Hey, Manu.
I'm for the petitioner. That is affidavit of service. My lord, there is an unauthorized construction in the place where I am the co-owner. In my absence, when I was out of the country, the private respondent has constructed building G+3 without any sanction plan. We filed a writ petition against this WPA 4417/21. An order was passed by the learned Justice Sinha.
Yes.
Directing the respondent to take this into consideration and pass reasoned order. And if it is found that it is unauthorized construction, then take action. They passed a reasoned order without considering my submission and without taking into consideration the unauthorized construction. Then I filed a RTI application to the Howrah Municipal Corporation. They replied the RTI with RTI information, page 22.
Page 22.
Page 22.
G+3, the building of it.
Where?
No such building plan has been sanctioned from Borough 3 office, but it may be sanctioned from building department because G+3 building, Borough 3 office is not the authority. This is the problem. So that does not mean that he may have a sanction plan, may not have it. I don't know. If your lordship directs me, I can come with a report from the building department, whether he has a sanction plan or not. But now the Borough 3 has no authority to deal with this. No representation also has been made. Only RTI application has been made. If representation is made, that also will be considered by the building department.
Yes, sir.
Before, after G+2, everything should be building department, not Borough.
Borough.
আমাকে time দিন আমি নিয়ে আসতে পারি report. Whether there is any building plan or not. If there is no building plan, immediate steps will be taken.
Yes, sir.
Yes, some may be directed for some report from the
Levin, you bring the report.
No, only one thing, the building department is required to be made a party. Let them add them a party. I will tell them which person. Only Borough 3 has been made a party, but that will not do. In any manner, your lordship.
Which order is he challenging?
No order has been passed.
This order, page 20.
Page 22, that is
page
the
20, reasoned order. Page 20.
Oh, Borough 3 says, as there is no truthfulness of the objection, last paragraph. Right?
Yes, that's what I'm reading.
That found after inspection and hearing the case is now dismissed until new construction started. Well, in fact, I want to file a report, even then also.
But what kind of this decision is?
That is my problem. That is also I am asking myself also. If your lordship directs me, I will come with a report. Your lordship may give me only 2 weeks time. I will come with a report.
Nothing, no documents have been taken. What kind of order is this?
Building start হয়েছে?
Building already construction হয়েছে এবং আরো হচ্ছে।
কতটুকু হয়েছে?
G+2 তো হয়ে গেছে।
এটা 2022 এ বলেছিল, তখন কনস্ট্রাকশন ছিল?
হ্যাঁ।
Sure.
হ্যাঁ, sure. Construction not থাকলে।
That was a report in the 2022. I don't know. I'm not supporting him. I will have to file a report. Order was passed in the month of July 2022 and report that this reasoned order has been passed. Order of the Honorable Court in the July 2022. Order of the Borough in 2022 December, after 5 months. He says after inspection it was found no building has been constructed, still started. So it is dismissed. I don't know what happened. I have to take instruction back. And I will also find out whether there was any inspection on 2022 and whether construction started on that date or at that point of time.
In reply to RTI, they are saying no such building plan has been sanctioned from Borough 3 office in respect of 241 Berelias Road.
But your allegation is not correct to that extent. No construction has started. You are just making all these false averments.
No. Construction has been done.
Where is it, sir? On record, where is it? Show me. What document you have placed on record to show there is construction? Where's the photograph of the construction?
Then I will,
Where is the photograph or anything put on record to show any construction? Don't file petitions like this.
next time I will come with the photograph.
What do you mean next time? Your petition should contain every detail, sir. You withdraw this petition, file another one. Learned counsel the petitioner.
I will file photograph.
What photograph? You file the petition. No allegation of unauthorized construction is here. You just file petitions just like that. The order is also innocuous order.
Construction is there.
On inspection, it records there is no construction.
No inspection.
Learned counsel. Sir, if you want, I'll dismiss it. You want to withdraw with liberty, I'll allow you. What do you want?
Actually, there is construction, but
Sir, what do you want? You want to withdraw this and file afresh, or you want me to dismiss this petition?
no, my lord. Actually, direct the authority to report.
Why should I ask the authority to report if I'm not convinced there is any unauthorized construction? The order passed by the assistant engineer says after inspection, there is no unauthorized construction. And if it will start, they will take action. Your writ petition, there is nothing on record to prove any unauthorized construction.
Actually, there is.
File a better petition. Learned counsel, the petitioner seeks to withdraw the present writ petition with liberty to file appropriate proceedings in accordance with law. Matter is dismissed as withdrawn. Next.
My lord, I am in this matter, my lord, for Urubidia municipality.
Yes.
My lord, in this matter, my lord, the record of the is it misplaced, my lord. I beseech your lordship to take on any other date, my lord.
Sir, why are you Mr. India? I can't see you. Please show your face.
My lord, I'm starting, my lord, but it could not be done.
You're for the municipality, right?
Yes, yes, my lord.
Who's for the petitioner? Item 72 and 74 are connected. Third July? 30th? No, 72.
72. 74.
Why?
72. Why?
None appears for the petitioner. Let this matter be same date. Same.
I'm for the petitioner. I'm praying for not written.
Your item?
74 and 72.
72, 74. Let both the matters be listed together. ठीक है वो rate का number देना. We'll keep it on 30th July.
Much obliged.
Take his appearance.
Much obliged. Govinda Chandra Bandopal.
The take down. The order sheet records that there was no appearance on behalf of the petitioner on 30th 8 2023, 9 10 2023, 16 11 2023, as well as today, full stop. It seems the petitioner is not interested in pursuing the present writ petition. Same is dismissed in default. Order sheet records, huh? Order sheet records. Records. The rest of the matters tomorrow.
But